you. All right. People against Kevin Denard Lee. Come on up to the podium, sir. 2587591, 275B87590. Your name?
Kevin Lee.
Okay. You guys, you haven't paid anything yet.
Oh, we just got the money. My mom took the money out her rent money.
I don't want her to take the money out of her rent money. Where is she?
She's on.
Go get her. Ma'am, can you come up here, please? How are you? Your name?
Clarice, wait.
I don't want you to take money out of your rent money. What? Where do you guys live?
Town 23471 Parker Avenue.
Is that a residence?
Yes.
Or a-
Town.
Oh, Hamptons, yes. Okay, I'm sorry. So I told you to come up with $200 back on that date. Back on October 15th, I should say. Do you have the money to pay your rent?
I'm taking it from my rent. So I got out of eviction and paid that. It's a new money. And
I don't want you to do that. Here's what I want you to do. Let's make this easy, okay? I don't want you to have to, I don't want you to get kicked out of your apartment or your house because of this. Give me 1 second here. Let me take a look at something, please. Ma'am, where do you work at? I'm sorry?
that with the medical team and everything.
Oh, I see. How much do you make there?
My checks are like 1,500 every 2 weeks. I've had to take a pay cut for my rent. My rent's 1,400 and my current is 6. So
Let's do this.
I have to do too much anyway.
Could you pay $50 bi-weekly?
Get paid every 2 weeks.
When do you get paid next?
14, but that's gone.
I understand. Let's make it, the 14th is this Friday, right? So why don't we make it, you pay $50 bi-weekly beginning. How about December 1st? Is that okay? Now, if you don't have the money, ma'am, I don't have a problem. What are you doing now, young man? Are you going to school?
Yes, ma'am.
Where?
Woodhaven High School.
How are you doing in school?
I'm doing very good.
How's his grades, ma'am? Are they better to B plus average?
I say yes.
He
Yes, ma'am.
got one bad grade, he working like that's a D. Rest of them is B's and C.
All right, you got to get your grades up a little bit. You played in sports?
I'm trying to get into sports now.
He's trying to wrestle coming up on.
You look like an athlete to me for some
He
reason.
missed football. He used to play football in Lincoln Park, and he missed it this year, so he's on the basketball.
They got good teams over there. You pay $50 bi-weekly beginning December 1. And then after fines costs paid on the 9-0 file, you pay on the 9-1. Okay? And if you need more time, you come talk to me or call up on Zoom at 8:30 in the morning on or before the due date. I don't want you missing school. You're going back to school now, right?
Communication,
Okay, all right. I'm easy to deal with if you just come talk to me, okay? All right, good luck. Thank you. Devin Sessoms. Devin Margaret Sessoms, 24F242601. Good morning. Again, how are you? Your name? All right, you're charged with failure to attend the ARM program between November 1 and November 2. There was a 2-day program. And then also count 2 alleges that you failed to provide proof of completing 54 hours of community service by February 1 of 25. And I realize we gave you additional time due to health-related issues. But those are the 2 charges. If you plead guilty or if you're found guilty, I'm just telling you, you have no prior technical violations, right? Or you have 6 prior technical violations, right? Your probation could be revoked. You could be incarcerated on this for up to 93 days. Do you understand that?
Yes,
Did you sign the advice of rights and read and understand the rights?
yes,
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
yes.
All right. You have the right to a lawyer. If you want one, I'll be happy to give you one. If you want a lawyer. Is to count 1. Can you call in, Sadie, please? Did you fail to attend the ARM program on November 1 and 2? How do you plead? Did you fail to attend the ARM program?
Yes,
To the charge, you failed to provide proof of completing your community service by February 1 of 25. How do you plead?
yes,
You failed to provide proof of completing your community service by that date? And again, you failed to attend the ARM program. Anybody forced you to plead guilty?
I get
No.
word.
All right, I'm going to accept your guilty plea. I find it to be an accurate plea. Devin, what is going on? You're giving me pause for concern here. This ARM program, how many times have you missed that now?
well, I missed it because I had the neck surgery.
Well, that we won't count, but
And I feel better than you.
I'm sorry, then what?
I had my gallbladder shortly right after.
Right.
And now I have more meds. It's a lot, I'm dealing with a lot. But I do.
Why didn't you go this week? Why didn't you go November, I shouldn't say this weekend, November 1 and 2? You're what?
This year.
State your name, please.
Baby.
Did you know about that?
Yes,
When did that happen?
that happened this, I believe it was the Friday before she was supposed to go to hospital.
And you're scheduled to start on, I'm sorry, community service when?
Tomorrow. And Friday.
And we can get her into the ARM program in December or not?
No, the next ARM program, I believe, is in February.
Okay, so the community service, you can do it any sedentary job. Nobody's going to ask you to walk around and pick up papers or get on ladders or anything like that. Okay?
I did find the Humane Society in Monroe, that's what I need to do it all there.
Amy, can you please give me a date in early January? I can expect your community service to be done by then, okay, Devin? We can't get you in until February. We can't get you in until February. I just need to feel like I understand issues arise in people's lives. I just need to feel like you're embracing this program.
Yeah, I said.
All right, give me a date in January, please, Amy.
January 6th. At 8:30.
at 8:30. And I'm gonna just make a note, community service to be completed, okay? I am so sorry about what you're going through. That's all I'll say. Sadie, anything else?
No, Devin, is compliant everywhere else. She's had some medical issues arise out of nowhere, so, I do think that, you know, the community service, I have given her a lot of opportunities to complete that. But if she's got it scheduled, then I think that's the right step forward.
So just have that done by January 6th, okay? And then we want to make sure we get you into the arm in February, all right? Stay with us now, okay? We'll see you back here. Go down the hall and get your sentencing date, please. We're going to give you a paper notice. Eric Stefan Kish, 25F244490. All right. Your name?
Eric Kish.
You're charged with failure to submit the weekly testing on November 2. They think you were unable to provide a sample after 2 attempts. If you plead guilty, if you're found guilty, this would be a first violation. You could get 5 days. Do you understand that? And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to give you one at public expense. You're entitled to one today. Would you like a lawyer?
No.
To the charge you failed to submit the weekly testing as ordered on November 2 of 25, how do you plead? Did you fail to provide a sample after 2 attempts?
Yes.
Anybody force you to plead guilty?
No.
Why weren't you able to provide a sample?
I have issues. Like, I have kidney stones. I do have referrals with a urologist here that I have an appointment the 20th now.
You got a test.
I honestly, I got there, I was there, but then it ran out of time and the clinic was closed. And I honestly didn't know about the short one.
Call in, I don't know where that is. John, can you call in Emily, please? You didn't have a problem going during the bond phase, did you?
Yes, I normally went in the morning and at night to make sure I was there for about an hour every time. And you only can go once and then you have to wait 30 minutes and then,
Do you have any medical documentation?
not having shy of the referral right now.
What's that?
Not having shy of the referral for the urologist that I brought.
Look, you're gonna need the test, you understand?
Oh, I know. Normally I go at least, that's why I go in the morning, so I can go at night, just in case, but Sunday they go into the night one.
And you never provided us with documentation, though, to tell us you have any kind of problem medically.
I went to urgent care, when I went to the IUPCP about a week or 2 ago, and so gave me the referral.
How are you finding this program so far?
It's a lot, but it's doable. Just getting scheduled and going, everything's the only difficult part of it. Okay.
I'm gonna need some medical documentation. I'm gonna set a sentence date. You're going to go test at DNA on the first available opportunity. I don't know if that's going to be today.
I think it's,
You did today?
yes,
Okay, so you didn't have a problem today? Right?
no, I was just there probably about 45 minutes or so, this is second attempt.
All right. I want to see those results before I sentence you. But I need you to be testing. If you don't test, I'm going to have to assume it would be positive. I'm just telling you.
Understood.
Lisa, Amy, give me a new date, please, for a sentencing date.
November 24th at 8:30.
That's good. At 8:30, okay?
Okay.
All right, I don't really, I'm not going to sentence you now. You're comply with all other terms and conditions of sobriety court, okay? Any questions?
No.
Go down the hall, get your notice, and you're all set, and I wish you well.
Okay, where can I get the notice again to?
All the way down to the end of the hall, to your right. George with John Demoo, 25W8402518. A and B. Good morning, Mr. Zelnick.
Morning, Your Honor. Step up there, sir. Edward Zelenak, appearing for Mr. DeMove. Mr. DeMove, please state your name clearly, audibly, and loudly.
George John DeMille.
Well, he's got a radio voice.
Yeah, that's I've been told that before.
What's that?
I've been told that before.
All right, Mr. Zelnick, does he stand by waive formal reading for purposes of arraignment? And then there's going to be a plea to allowing unlicensed driver to drive. The driver will suspend, revoke, denied, will be dismissed. And he's also going to plead to impeding with the speed to be dismissed. True?
Yes, Your Honor, and so the court is satisfied that he's taken the steps. He has not had a license for over 11 years. He's already enrolled as a substance abuse therapist and hired several lawyers much smarter than me to get his license.
I doubt that. Not that he hasn't hired a lawyer, but smarter than you. All right, sir, do you understand what your lawyer has said?
Yes, Your Honor.
If you plead guilty to allowing an unlicensed driver to drive and responsible to impeding traffic, I'm going to go ahead and dismiss on motion of the prosecutor the drive while suspend, revoke, denied, and the speeding. Do you understand that?
Do Your
You
Honor.
agree to that?
Yes,
If
yes.
you plead guilty, the possible penalties on the allowing unlicensed driver to drive are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand an advice of rights form here today?
I did, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
All right. Any questions? Charge allowing an unlicensed driver to drive. How do you plead?
Not guilty.
I'm sorry. I have to ask you again. The charge allowing an unlicensed driver to drive. How do you plead?
Guilty.
Were you in control of a motor vehicle on October 16 of 25 at 9:34 a.m. that was being operated on I-75 southbound near West and Woodhaven?
Yes, Your Honor.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
To the charge impeding traffic, responsible or not responsible?
Responding.
Please accept it to allowing unlicensed driver to drive. Please accept it to impeding the revoked, suspend, denied is dismissed, as well as the speeding. He's got a revoked license. That doesn't excite me. Why is he driving around? Why haven't you done this a long time ago? What, Mr. Zelnick, can you want to offer an explanation?
He just retired as a banker and now he's controller of a concrete company and I have no idea, but his wife drove him here today. That's all I report, Judge. I can't make people do things when they leave my site control.
I got it.
My children, I try my clients, doesn't work anymore.
One doesn't work is right. Anything? Why haven't you gone?
Well, Your Honor, I'll be honest, life basically.
You're honest.
Yeah. Life, I had to take care of my young family, get them to school, get them to college. My elderly mother for over 35 years, I was taking care of her. She had health issues. My mother-in-law, just life itself. I'm working 60, 70 hours a week as a banker and running a group, a lending group, it basically got away from me and I didn't take responsibility, which I should have. And that's
Okay, because you had another accident 3 years ago. You can't drive if you don't have a license. I'm gonna go light, but don't come in front of me on one of these again. We got it?
yes, sir.
Anything else, Mr. Zelnick?
No, I left my violin out in the parking lot. I heard his story, I was bring the violin. But I mean, it's the same answer you hear from everybody. So you understand, you're much smarter and much more intelligent than the average driver. This is really irresponsible. Judge, whatever you find, he'll take care of it today.
100 fines, 235 costs, 75 victims' rights, $50 justice assessment, 460 or 93 days, and 195 on the speeding. So you owe the court, what did I say, 460 on the, 460 plus the 195, 560, 655. Can you pay that?
Yes, sir.
You can go down the hall and take care of that. Please don't come in front of me on these again, okay? Thank you, Mr. Zelnick. You have a great day. Aiden Michael Medina, 25W840266 A and B. You can come on right up to the podium here, sir. Could I have Grant Galaska? Have a seat at the table right here, sir. You come on up to the podium, Mr. Medina. Your name? Name?
Peter Virginia, sir.
You have the right to a lawyer. You're charged with drive while suspended, revoked, denied, and no proof of insurance. There is a warning on the expired plate, but that's irrelevant for purposes of this hearing. So you have the right to an attorney. I'll be happy to provide you with one at public expense if you would like one. Would you like one?
No, thank you.
So I'll go ahead. I'll arraign you. I'll let you go talk to the Woodhaven City Attorney, okay? On October the 13th of 25, it is alleged that you did at 11:35 PM. Operate a motor vehicle on Van Horn near Reek and Woodhaven. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, costs are all those and 2 points. Do you understand that?
Yes, Your Honor.
You're also charged with no proof of insurance. That is a 0-point civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights form here today?
Yes, Your Honor.
If you plead guilty, you will be giving up all those rights, and we are not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. Do you still wish to waive your right to a lawyer?
Yes, Your
I'm
Honor.
going to enter a not guilty plea. I'm going to give you a $500 personal bond, okay? And here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. He must appear in court as directed. You go down the hall, I'm sorry, out in the hallway. He's going to take this file to the prosecutor right now. And you'll go meet with the prosecutor. If he doesn't give you what you want, then you can always come back in here if you can't afford a lawyer and fill out a petition for one. Understand all that?
Yes, Your Honor.
You're all set. Go out in the hallway and he'll set you up. And either way, you're coming back in front of me, okay?
Thank you, Your Honor.
Best of luck. Grant Avery Glasgow,
Yes.
25 W838970. Your name, sir?
Right, neighbor, Alaska, Your Honor.
You are charged with stalking and you have the right to an attorney. Would you like an attorney?
I would like to speak with one, yes.
Okay. I'm not even going to arraign you. I'm going to send you to the lawyer. The lawyer and you will come back in here as soon as he's had a chance to talk to you. Do you understand that?
Yes, sir.
All right, you can go out in the hallway and we'll go from there. Ganos, Thomas Edward Ganos III, 25W840330A and B. Your name, sir?
Thomas Edward Gaines III.
All right, you're charged with drivewall license not valid and no proof of insurance, and you have the right to an attorney. I'll be happy to provide you with one at public expense if you would like one.
Yes, please. I would like my time, please.
Okay,
Your Honor.
we're going to set you up with a lawyer.
Thank you, sir.
So you can go out in the hallway and you'll speak to the Woodhaven City Attorney, okay?
Thank you, Your Honor.
Thank you. And then either way, you're coming back in front of me.
Thank you, Your Honor.
Goes to the prosecutor. I'm sorry.
Yeah, he's got to speak
That goes to the lawyer. This one goes to the prosecutor. That one leads right to a lawyer. Is your lawyer ready on that case yet?
Not yet. The prosecutor, I believe.
Yes. Okay. As soon as he's ready, I'll call your case, okay? If Mr. Crawford's ready on that, John, if you want to see if he's ready. Have you talked to him today, man?
Yes, I just.
Okay, good enough.
on Davius Alexander.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Alexander. Mr. Alexander, state your name for the record, please.
Davius Rayvon Alexander.
Thank you.
Your Honor, we are here for sentencing. We did review the pre-sentence report and don't have any material changes, additions, or deletions. I ask that you adopt the recommendation.
All right. Mr. Alexander, anything you want to tell the court before I impose sentence, sir?
No, sir.
All right. Sentence of the court, $125 statutory fees, 93 days in jail, credit 93, sir. All right. Thank you, sir.
All right, take care.
Court calls the case of the people of Ibrahim.
Your Honor, this is a show cause for failing to pay fines and costs.
Does not have counsel.
Correct. I am trying to.
What do we have as a balance? No, I got it. Okay. Sir, state your name.
Ibrahim.
All right. Mr. Ibrahim, you're not, this is a show cause. You're not represented by counsel. Did you want to be represented by counsel?
Yes, please.
I'm not sure how this.
I mean, is it necessary? You said it's a show cause just for non-payment. I'm in prison now. I don't have.
Right, it's a show cause for non-payment, but I will give it counsel just in case. But so this is a public defender case. If you can step in, I would indicate that Mr. Alman, I think, represented Mr. Ibrahim at the previous one, but I cannot tell whether that was because of a conflict or whatever, but.
I would, Assistant Public Defender Natalie Pate with on behalf of Mr. Ibrahim. Your Honor, I don't have the balance right now that Mr. Ibrahim would owe, but I do know, because I represent him on another case, that he was just transferred to MDOC on October 31st from the Washtenaw County Jail. So I believe it is anticipated he would be there for some time. I would ask for at this time an adjournment of the shown cause.
How much do you have him? I have him with 410.
That is correct.
410. Mr. Ibrahim, have you been sentenced to MDOC time?
Correct.
All right. What is your sentence?
23 months with credit of 15. So I should be out June of 26.
Got it. And this is okay. So this is a trespassing case.
I'm sure.
So with a 30-day maximum on it. And the only reason the fines and costs are where they are is because he didn't pay them back in 2021 because he was busy with other stuff. No, I'm just messing with you.
So I've been arraigned on this. I've been arraigned and I already pled on this, or I thought this was a new charge.
Yeah, you pled on it back in on January 20th of 2021. You pled on it. No, it happened April 8th of 2019.
Yeah, I wanted to go to trial on this. I wanted to go to trial on this case. I wanted to go to trial on this case. I never meant to plead on this case or anything like that.
Well, you did though.
Can I withdraw my plea?
So you want them to file a motion to set aside on a trespassing?
Yes, because I mean, I paid for the ticket. I was there at the movie theater. It was a whole incident.
Paid for what ticket?
Mr. Ibrahim, I wouldn't talk about the case.
Talk about the case. I mean, if he's going to file a motion, says, I was going to tell you what I was going to do.
Yes.
What I was going to do was just waive everything except the state minimums and just close it. But if he wants to adjourn it out to motion to set it aside, I don't know that I can do that after 4 years, but I'll give you a shot at doing it.
In that case, Your Honor, Mr. Ibrahim, go ahead.
No, go ahead.
In that case, Your Honor, if Mr. Ibrahim is wanting to proceed in that fashion, I believe our office may withdrew because of a conflict, and if that is what he wants to do moving forward.
But I don't know who's gonna, he wants to, well, it doesn't make much sense to me, and I don't know that I can do it anyway, but here's what I'll do. I'll adjourn this out. Give me a date, February.
What about the two driving while license suspended? Am I going to be seen on that today as well?
No, Mr. Ibrahim.
I don't have those in front of me, sir. February 4th. During this matter, February 4th, 2026, 9 a.m. Continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Robert Greenshields.
Ready, Your Honor. Robert, back to Mr. Greenshields. Mr. Greenshields, would you state your name for the record?
Robert Claude Greenshields.
Judge, at the time we adjourned this out, we thought Mr. Greenshields was still in the Oswego jail. Mr. Greenshields, what's your status now?
I was released on November 5th.
November 5th?
Yes.
All right, thank you. Judge, it's my understanding probation would like to, the full interview has not been done with my client.
It hasn't been done.
Right.
All right. So I will re-refer to defendant to probation for pre-sentence investigation and report. I'll set a PSI appointment for you for November 25th, 2025 at 10 a.m. That's in person at the probation department. All right, sir?
Yes, sir.
All right. And I'll adjourn his sentencing to December 10th, 2025, 9 a.m. All right.
Mr. Greenshields, can you give me a call, okay?
Continue.
Do I have a phone number?
Judge, can I put it?
Know. You can give it to him if you want. I'm going to call you now too.
Pardon me?
Nothing.
Yes, I'm ready.
That's okay. 734
Yes.
417 5714.
All right, thank you.
Thank you.
All right, thank you, Mr. Greenshields. Court does call the case of the People versus Kwame Edwards.
Edward Brooks on behalf of Kwame Edwards.
All right. Go ahead, sir.
Kwame Edwards. All right. Thank you. Today's the time and date set for sentencing. I've reviewed the pre-sentence investigation report with Mr. Edwards, and there are no additions or corrections. We would ask the court file the recommendation. He is getting a paycheck here in the next week or so. He is employed. Yeah. So he's just asking for a little time to make some payments.
All right. Sir, anything you want to tell me before I impose sentence?
Can I get like my sentencing, like a printout of it? Because I had issues with my court date recently. My phone's broken, so I really can't keep track of things right like that.
So you need a paper copy of what I sent you?
That'd be for the best.
What did you say?
That'd be for the best.
I think we can arrange for that, Your Honor.
That's really?
Really?
I'm pretty sure we can. I'm gonna walk him down.
I don't know if I want to do all that. Ms. Valera?
Your Honor, he will have a probation order, which will have all the terms that you set forth. He can also go to the clerk's office and they can provide him with a copy of the ROA.
Thank you. Because it was going to be hard for me to get up and make a copy. Because they don't let me touch the machine.
Okay. No,
I didn't break it.
It was after the incident?
What?
After the incident?
After the whole incident. And then the fire. But no, I'm kidding. All right. All right, sir. We'll make sure you have that in, either you can get one today or we can make sure that when you sign your probation order, you have a copy. All right. Anything else you want to tell me?
Nothing really.
All right. Sentence of the court, 9 months probation. You pay $555 fines and court costs, $270 probation oversight fees. When can you pay that?
It'll take a few months, but I'll start payment probably tomorrow.
You can pay something tomorrow. What can you pay tomorrow?
Probably 150.
150. All right. Why don't we do this? Tomorrow's Thursday, so the 15th. What's Friday, the 14th?
Yes.
So pay the 150 by this Friday, the 14th. Okay. 2025. And then how much you gonna pay every other week or you gonna pay
Every other week, that's what.
every other week? So how much you gonna pay every other week?
It depends on how many days they have me. I work part-time at a Dollar Tree, so sometimes they only.
All right, here's what I'll do. Then a payment plan every other week is arranged by probation.
Thank you.
Okay, so they can go through that with you. There should be no use of alcohol, marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the behavior modification class within the next 60 days. There's to be no assault or threatening or intimidating behavior by you. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. I'll order 365 days of jail. Credit to the balance is suspended. Okay?
Thank you, Your Honor.
Thank you. No, I don't. Well, on some cases, I do. Court calls the case People versus Salvatore Lorenzo.
Good morning, Your Honor. Sam Bernstein. Good morning, Your Honors. Sam Bernstein with and on behalf of Mr. Lorenzo.
Salvatore Lorenzo.
All right, very good. All right.
Your Honor, we've looked at the recommendation. Mr. Lorenzo has been very proactive in addressing the concerns that brought him here with the early intervention and seeking counseling, and that looks like it's reflected in the recommendation by Ms. Plara, so it certainly seems fair and appropriate. The only thing we're asking for and hoping for is if there's any consideration that the court can provide with the ultimate fines and costs, it would be super appreciated. Mr. Lorenzo is a working man, but of modest means, and it's a heavy chunk of his take home.
Sir, anything you want to tell me before I impose sentence?
I just want to reiterate that, my decision to drink and drive was reprehensible. I'd endangered a lot of people for no reason. And one basic moral tenet I hold is to be a giver, not a taker. I feel I have a long road to rectify that.
All right. The good thing is, if there is that you're here to say all that and realize it, right? Because it could have been very different. Right. Okay. Sentence of the court on count 1, 12 months probation. You are to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, $360 probation oversight fees. There's going to be $555 additional that I'm going to assess on count 2. How are you intending on getting that paid, sir?
I could do a payment plan. I get paid on Fridays.
Every Friday, or you get paid every other Friday?
I get paid every Friday for my first job and every other Friday for my second job.
Okay. All right. So how would you like to start this payment plan? I'll work with you, but.
Yeah. It would take me a couple months to pay, more than a couple months to pay the entirety. I could pay maybe $150 this Friday.
Okay. So you can pay $150 on the 14th. All right. And then with your other bills and everything, is every other Friday then every 2 weeks? Would that
yeah, I could do every 2 weeks, $150.
All right. 150 every 2 weeks?
Yeah.
Okay. Let's do it that way. $150 every other week. All right, Joe paid in full. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the early intervention program, which you already have done, and that is completed. You continue individual therapy with proof to probation. Provide proof of the victim's impact panel attendance to probation. That has also been done and is completed. I'll continue the sober link for an additional 30 days in lieu of 3 days of jail. I'll order 93 days in jail. Credit to the balance is suspended. On count 2, the attempted R&O, 12 months probation, $555 fines and costs. That will be paid pursuant to the payment plan we just worked out. So all of that's encompassed in there. No assaultive or threatening behavior, no assaultive, threatening, or intimidating behavior. There's to be no possession of weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to comply with all of the terms as set forth in count 1 that I laid out. I'll order 365 days in jail. Credit 2, the balance is suspended. All right, sir. Thank you.
You're not.
I do. There it is. So, so I know Jay. Yeah. If somebody comes back and knows that. Court calls case, People versus Charles Peters.
Ready, Your Honor. Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Peters, approaching. Please state your name.
Charles Peters.
Mr. Peters and I have reviewed the assessment and the probation recommendation. There are no omissions that I'm aware of. I would ask the court to adopt the recommendation from probation. I'll just note that Mr. Peters, he did complete the victim impact panel November 8th. He's got a receipt to show Ms. Pilara. He also has been enrolled in the Dawn Farm Intensive Outpatient Program, had his first meeting yesterday. So that's all been positive. His parents are here. They've been very supportive. And this has been right over here.
Oh, they're there. Okay.
An opportunity for Mr. Peters to go even deeper in learning and growing and understanding more about recovery and how important it is to be aware of oneself and also take the opportunity as a positive step forward. And I think he's done that. He's been compliant with the court's orders and is prepared to pay the fines and costs off, I believe, today.
Okay. All right. Is there anything you want to say before I impose that?
Yes, Your Honor, that I'm deeply ashamed and remorseful for my actions, that I'm loving the support and community I'm finding in recovery. And I will never let this grossly irresponsible action happen again.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and continued abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. That is to be paid today.
Yes, Your Honor.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient treatment program, including all aftercare recommendations with status reports to probation. You are to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation, which I understand you have.
Yes, sir.
All right. I will continue the sober link for an additional 30 days in lieu of 4 days in jail. Order 90 days in jail. Credit 1. The balance is suspended. All right.
Thank you.
Thank you very much, Your Honor.
All right.
Court does call the case of the People versus Michael Burke.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who appears via Zoom. Mr. Burke, can you please unmute, turn on your camera, and state your name for the court?
Not here.
Your Honor,
You look confused.
I do. I don't have an explanation for his failure to appear, and frankly, that does very much surprise me. Would Your Honor consider passing the matter so I could text him? It was the only time I asked this today, I promise.
Today, right?
I promise, I think
She made it very clear. This is my one request today.
Yes. I think it's a promise I can, today, I think I can stick to this promise today. I think that's the word I'm looking for. Stick to it, uphold my promise. Yeah, that's the word I'm looking for.
66 A and B. Your name? All right, so you waived your right to a lawyer. I'm going to go ahead and give you a court date. We're going to adjourn this out. I'll give you 4 weeks. That's the best I can do, though, okay?
Thank you, Your Honor.
Give me a date 4 weeks out, if you would, please, Amy.
December 10th at 9 o'clock.
At 9 a.m., okay? Okay. You can go down the hall. We'll give you a paper notice, all right?
Thank you, Your Honor.
Have a good day. Good luck. People against Ollie. Dad, Juan, Derek, Auguster, Ollie. Got to take your hat off, sir. 22B1408578. Sir, your name, please? And his lawyer is who? John.
Miss Patillo, I'm admitting her right now.
Okay.
What is it?
Good morning, Ms. Patillo.
Good morning, Judge.
I just need you to start your video, please.
All right, is that Mr. Auguster?
Yes. Your appearance?
Deon Patillo, P82378 on behalf of Mr. Auguster. Mr. Auguster, state your full name for the court if you haven't already.
Laquan Derek Auguster Ali.
I believe this is part of the March 223 show cause. Failure to attend the scheduled probation visit on March 2nd of 23. Failure to register for, attend, and complete alcohol education program level 2, and failure to pay fines and costs. Balance $12.50, although I will acknowledge there was a garnishment. I'll check on that momentarily. Count 4, that he failed to enroll in monthly chemical testing as ordered on February 6th of 23, and count 5, that he failed to provide proof of completing 8 hours of community service by February 10 of 23. How is he going to proceed on these, counsel?
So, Your Honor, the failure to report he would plead guilty on, he indicated to me that he has a certificate at home for the alcohol education. And as Your Honor already stated, he had a tax intercept for $1,200, so there should only be $50.
Okay, so let's start with the alcohol education program. The charge is failure to register for, attend, and complete. I need proof he doesn't get to keep it in his drawer somewhere. So does he want a hearing on that? If he does, that's fine.
Yes, because
Yeah, let's bring in Emily Tessino, John. All right, so he's going to plead to count 1. What about count 4 and 5?
I completed.
Hang on, sir. Hang on.
Yes, sir.
Let your lawyer talk right now.
Yes, sir.
You like to ignore courts. We're going to put a star on your forehead.
So, Your Honor,
Yes.
it's count for the 8 hours of community service?
No, this is, wait a minute. Hang on. This is the March 2 of 23. He's got 5 charges. Count 4 is failure to enroll in monthly chemical testing is ordered on February 6 of 23. Count 5 is failure to provide proof of completing 8 hours of community service by February 10 of 23. What's he going to do on those?
Your Honor, he would have to plead guilty with an explanation.
Is that what you want to do, sir?
I completed the 8 hours of community.
Hang on.
Yes, sir.
Your lawyer just told me you're going to plead guilty as to counts 1, 4, and 5. We're going to take up the issue of the fines and costs on count 3, and that you're telling her that you completed the alcohol education program. So we're going to have a hearing on that. If you want to have just listen. Do you want to have a hearing on counts 4 and 5, failure to enroll in monthly chemical testing as ordered on February 6th of 23? If you do, no problem.
Mr. Augusta, understand you have to provide proof to the court of everything that you completed. Do you have that proof?
I'll have to, once
Tell you what I'm going to do. I'm going to make this easy. We're going to enter a not guilty plea on all of those. And as soon as Ms. Tessino comes in, I'll take testimony and you'll have the right to testify or remain silent if you so choose. And we will go from there. Okay, so I'm entering a not guilty plea. Did you call her, John?
Call me around. Just trying to find the file.
Because the file's old. Because the defendant doesn't like to show up. He's got other warrants out too. So we'll wait. Detective, just bear with us. I'm going to go on to another case. It should not be long.
Okay, thank you.
People against Miracle, Rodney Dean Miracle, 25W838504, 24W834355. A and B, come on up to the podium, sir, and tell me your name, please.
Rodney Miracle.
On October 26th of 25, the police think you operated a motor vehicle without a valid license. I also have a driveway license invalid charge. And I have 2 counts of driving while license invalid. Let me see here. April 15 of 24 and October 26 of 25. And I also have a charge of failure to pay on the improper lights rather. You posted a bond on that. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No.
Sure?
Yep.
All right. On October 26 of 25, it is alleged that you did operate a motor vehicle without a valid license on Holner West in Woodhaven at 3:35 in the morning. That is a misdemeanor punishable by up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And you also have a charge here for the same offense from April 15 to 24. Same possible penalties. Do you understand that?
Yes.
And then you also have a charge of failure to pay $213 on the unauthorized lights on file 355B. If I find you didn't pay and your failure to pay was not without your fault, you could be held in contempt and incarcerated 1 day for every $10 owed. Do you understand that?
Yes.
All right. Did you sign an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
Do you still wish to waive your right to a lawyer?
Yes.
All right. I'm going to enter a not guilty plea on the driveway license invalid charges. I'm going to give you a personal bond on both of those. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You do, well, on 55A, I'm continuing your $300 cash bond that was posted, it's 3,010% that was posted by Natalia Moreno. And then you also have, and I'm entering a not guilty plea for you on the other file, the contempt charge. And I'll let you go talk to the prosecutor. So what I'm going to do is we're going to handle all 3 of those. If he doesn't give you what you want, you can apply for a court-appointed lawyer. And also, I want you to understand that Ms. Moreno would have to be here for us. Where is she? Is she a girlfriend or something?
Yeah, she's my kid's mother.
I'm sorry?
Yeah, she's my kid's mother.
All right, well, I'm gonna need somebody to convey to us that they want us to apply the bond if that's the case, okay? She doesn't have to, but then we're gonna proceed accordingly. So you go back and talk to the prosecutor, and either way, you will come back and film, okay?
Okay.
Thank you. Recalling that one, Derek Auguster Ali, 22B 140-857A. All right, Ms. Tessino, your name again? Mr. Auguster, your name?
Detwan Derek Augusta Ali.
Ms. Patillo?
Deanne Patillo, P82378, on behalf of Mr. Augusta Ali.
Detective, your name, sir?
Detective Plath, Brownstone Township Police Department.
So we are dealing just because he doesn't like to show up. He doesn't.
File, I'll be honest, I didn't know what you needed him for.
Well, he's in custody from a 5-count arraignment on a probation violation, 5-count charge, I should say, that's dated March the 2nd. He was supposed to be here March 16 of 23, and he didn't show up. So I'm going to ask you to go get that file. No, Ali is the last name. Augusta Ali is the last. So I've entered a not guilty plea form. He's pleading not guilty. People against Benson, Nicholas Allen Benson, 25B147801A, B, and C. Good morning, sir. Your name?
Nicholas Allen Benson.
You're charged with driving on a suspended. Another one. Where you been?
I've been in Oakland County
Oakland County Jail?
for the last 7 months, yeah. I did 210 days. Jail 1.
Nice. Nice.
I literally just got out last week, so I was
Drive while suspended from February of 25.
Yeah.
Resist and obstruct from February of 25. No proof of insurance, failure to pay. You have the right to an attorney. Would you like an attorney?
Yes, please.
Okay, we're going to set you up with a lawyer. You go out in the hall.
I can.
Either way, you're coming back in with your lawyer after you speak to your lawyer. Okay?
Yep.
John, prosecutor.
Just gonna sit in the hall. Come sit in the hallway.
Go right out in the hall. It's going to the defense lawyer. Do we have somebody besides Mr. Crawford?
Yeah, I've been given a couple.
Good. LaFord. Anthony Joseph LaFord II, 25W840-437. Good morning, sir. Your name? You're charged with violation of instructional permit. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? So that's what you're charged with, violation of instructional permit. They think that you operated a motor vehicle while on a temporary permit without a licensed driver in the vehicle with you. This allegedly occurred October 14 of 25 at 9:43 p.m. on Western Allen in Woodhaven. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yeah. Yes.
And did you sign the advice of rights and read and understand the rights?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yeah.
All right. You still wish to waive your right to a lawyer?
Not contested.
I'm going to send you to the prosecutor first. You don't have to plead to anything right now. Let me send you to the prosecutor. So do you want to waive your right to a lawyer? I'll enter a not guilty plea, and I'll send you to see what you can work out with them. Okay. Personal bond, $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to take this one to the prosecutor. And you'll come back in front of me after you speak with the prosecutor. Do you understand all that?
That's there.
Yep. Okay. Any questions? Good luck. Tell Mr. Crawford I'd really like to move.
If I can find him here, I can call him.
What's his number?
271.
Mr. Crawford, I'm ready on a couple, whatever you have ready. Even if you have this one young lady sentencing, we can do that. If you have another one, great, but let's get her out of here, okay? Thank you. Okay.
I apologize. They didn't tell me.
No apologies necessary. People against Datwan Derek Augusta Ali, 22B 1408578. Your name again, sir?
Datwan Derek Augusta Ali.
Ms. Patillo, your name?
Dion Patillo, PA 23378 on behalf of Mr. Augusta Ali.
Ms. Tessino, your name? Raise your right hand, Ms. Tessino. So we're going to proceed on all of these. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes, sir.
Okay, go ahead.
Yes, I have had no contact with Mr. Ali since March of 2023. I just kind of flipping through the file. I do have proof that he completed the victim impact panel. But beyond that, it doesn't look like he completed anything else. He never enrolled for the class with PERS. Morning, Ms. Patillo. And he never reported board testing to even enroll. So he never tested off his probation.
All right. And he did not provide proof. Let me just go through. And you don't have proof that he completed the alcohol treatment program, correct? The alcohol education program?
Alcohol education. I just want to flip back because I do have proof of 8 hours, but it looks like you. Trying to see if you gave additional hours. So I have proof of 8 hours that you ordered at sentencing, but I do not have proof of the 8 hours that you ordered as a result of a violation on October 11th of 22.
All right. And he didn't show up for chemical testing on February 6th of 23. And he didn't provide proof of completing the 8 hours of community service by February 10 of 23. And he didn't pay his fines and costs as he was ordered to. And he didn't provide proof of attending and completing an alcohol education program level 2, correct? He didn't appear for probation on March 2 of 23 with his appointment with you, correct?
Correct.
Any questions of her, Ms. Patillo?
Yes, Mr. Augusta Ali, do you have a certificate at home showing that you completed the alcohol education?
Yes, ma'am.
Okay, and in terms of the chemical testing, did you register?
No, ma'am. But I told you I got my rehab certificate and everything for completing rehab.
But did you register for the chemical testing?
No, ma'am.
Okay, and in terms of your fines and costs, was there a tax intercept for $1,200?
It was between $100 and $200, $1,200, or it was $975 to $1,200. I got the paper at home with the receipt from Woodhaven Court.
So you still have a balance that you need to pay?
Yeah, I believe so. Probably like $100 or $200.
Okay, and then did you report to probation for a probation visit on March 2nd, 2023?
I had so many deaths in the family, I couldn't really tell you. I told you I'd take care of my grandparents and everything, so I really don't remember.
So if you did fail to appear, was it because you had some family issues?
Yeah.
Okay, Your Honor, I don't have any further questions.
Your tax garnishment was issued sometime around May of this year, correct?
Yes, sir.
Did you ever call when your grandparents had this issue on March 2nd and reschedule your appointment?
I could take full accountability. It's all on me. It's my.
Wait a minute. Did I swear him in?
Oh, I thought you were talking. I'm sorry.
Did I swear him in?
I don't think so, Your Honor.
I don't either. Raise your right hand. You solemnly swear affirm under penalties of perjury. Put your hand up, sir. If he's going to testify, you want him to testify, right?
Yes, Your Honor.
You solemnly swear affirm the testimony you give in these proceedings will be the whole true self you got. Yes or no, sir?
Yes.
So you can put your hand down. So you're telling me you went to the alcohol education program?
No, I didn't. I didn't say I completed the assessment.
And you're telling me that your grandparents were ill on March the 2nd of 23, which is why you didn't report.
Been ill for years, yes, sir.
And you're telling, hang on, just let me finish. And you didn't pay your fines and costs as you were ordered to, correct?
Yes, sir.
I'm correct?
Yes, sir.
And you didn't provide proof of completing your 8 hours community service by February 10 of 23, correct?
Yes, sir.
And you didn't enroll in monthly chemical testing as ordered on February 6 of 23, correct?
Yes, sir.
I'm right?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
Any argument, any other questions of him, Ms. Patillo? I'm sorry, Ms. Tassino?
No, Your Honor.
Do you have any other questions of him, Ms. Patillo?
No, Your Honor.
Hello? Wait 1 second, man. All right. Any argument at all, Ms. Patillo?
Yes, Your Honor. Mr. Augusta Ali did indicate to me that he's had some deaths in the family. His grandparents are ill and he does care for them. He is employed at Bruce. He's been employed there for about a month, but prior to that, he was employed at Tech for 3 years. He doesn't have any children. I understand that there are other outstanding warrants, Your Honor. So in terms of the probation, I don't know if the court is going to close the probation out with time served. I would just ask, whatever the court does do, take into consideration that he is employed.
When did he serve?
He did serve 10 days.
Wow.
He served.
Anything else you want to say, sir? We count the number of days, please.
I was just trying to see if I could do like house arrest or like an alcohol tether or whatever, because I completed probation and everything. I just need to be there for my grandparents and just make sure that they're all right. That's all.
Missed.
It looks like he gave him 1 day jail credit, I'm assuming with the night he served when he got arrested. And then he has a 4 day, well, technically, he has 2 days jail credit for court work, 1 credit for community service day, and then you gave him 10 days.
On top of those?
Yep, on top of those.
So he served 14 days. When was he picked up, Detective?
Your Honor, he was brought in, it's dated the 12th today.
Where were you picked up, sir?
The Livonia traffic stop. My buddy was driving. We were just getting off of work, and I was just being honest and gave the officer my first and last name, and that's why I'm here now.
You went out and got another zero tolerance drunk driving, so to speak, as a minor right after this, after you failed to show up. That's bad.
Yeah, that's bad.
Let me just finish.
Yes, sir.
You don't get to do this. You don't get to do this. You got warrants out for your arrest. Let's see. 1 out of Southgate, 1 out of Westland, 1 out of Mount Pleasant, 1 out of Taylor, another out of Taylor, and another out of Taylor. I don't know what you're thinking, sir. How old are you now?
I just turned 22.
You better reevaluate, because you probably got, if you take care of yourself at all, another 55, 65 years. If you're going to go through your life acting like a criminal, it's going to cost you. I don't know why anyone would think at any time that they don't have to show up for a court date. That's just me. Maybe I'm wrong. Maybe we've gotten to the point where people think it's a voluntary appearance. You made no effort here and then you went out and committed another crime. Probation's revoked. You're to pay costs of $175 and serve 93 days, credit 15 for 78. If you pay 175, I will suspend 48 of the 78 and you'll only have to serve 30. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You pay 175, you'll be out in 30. Otherwise, sir, you're going to be in there for 78. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. I wish you well. Good luck. Thank you. You have that one from Mr. Jadala.
Thank you, Judge.
Good luck, sir. Thank you, Ms. Patillo. Does Mr. Jadala's, let me see here. Do you have Dalawal counsel or not?
Your Honor, I have Mr. Siddiqui.
What do we? Mohammed Majid Siddiqui, 25W840-279. Good morning, Mr. Jadala. Your appearance?
Good morning. Respectfully, Sam Jadala, P62186, appearing on behalf of Mr. Siddiqui with the authority to enter into the proposed plea before this honorable court.
This is going to be plea to impeding with the distracted to be dismissed. True?
That's correct, Your Honor.
This is a commercial vehicle, though, right?
Correct, Your Honor.
Okay, they wrote it up differently, or at least the computer printed out. To the charge, and you're authorized in this plea to impeding?
That's correct, Your Honor.
On his behalf, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. 205. I'll give him until the 19th to pay, and I'm dismissing the distracted. Okay?
Thank you, Judge. May you and your staff have a wonderful day.
You too. Thank you. Rashpal Kaur Dalawal. 25W840-226. Attorney Voiles out there, Amy? Looks like Voiles.
Yes, Judge, I'm admitting her now.
What's that?
She's coming in right now.
Oh, okay. Good morning, Ms. Voiles. Your appearance? Ms. Voiles, I need your appearance, please. Unmute and start your video. All right. Where is Mr. Crawford again?
Walked in with the.
I know. Dustin Lee Hawk, 25W8375118. You have Mr. Crawford is your lawyer, right?
Yeah.
Have a seat right at the table here. People against Ebony Allen, Hunter Smith, 22W829943, A and B.
Good morning, Your Honor. Michael Crawford, representing the defendant's approaching.
Ma'am, your name?
Smith.
She pled to attempt Arenal on file A, and she pled to operating while impaired on file B. Counsel, the more I look at this, she needs variety court.
The court hopefully will have plenty of time to consider this, and also my client to consider this. She's asking for an adjournment. She'd like to get retained counsel, but she'd like to consider her options to challenge her earlier.
How long is this case going to take?
She's just asking for another 2 or 3 weeks.
2 or 3 weeks? Why didn't she do it since she was here?
Well, Your Honor, she would have. However, she's having a scheduling conflict between her work conflict and the attorneys that she was reaching out to. She just couldn't connect.
Come on. This case been going on since 2022, man. Did you hear what I said? Did you hear what I said? I was younger in 2022. I'm not going to keep delaying this. You don't show up for 3 years. What kind of nonsense is this? I'm just telling you, she better reevaluate right now because I expect her to get into sobriety court. She's got all kinds of convictions here. Amy, what's the earliest date I can give this young lady here?
If it has to be on a Woodhaven day, we don't have Woodhaven again until December 10th.
I'm not doing that one. When's Mr. Crawford here again? She said 3 years to get a lawyer.
Mr. Crawford is here for Judge Hessen's probation docket on 11/18.
It's gonna be here.
Well, I know, but she's had 3 years. She said 3 years.
He's also the overflow on 11/20. The arraignment attorney on 11/24.
But four would be great, Sean.
November 24th.
Thank you.
At 8:30. We're gonna start at 8:32, okay? I think she needs to get into sobriety quick myself. Okay?
Still,
I thought I just adjourned. Did I just not adjourn this 2 weeks ago? I thought I adjourned.
we had just explained, I should have some difficulty getting to this point. Scheduling, they her work, her schedule and the council she had reached out to. That's why she said there's a little bit of time, You'll be ready.
She had 3 years, though. I just want to be clear. 3 years. 3 years. She's not taking this very seriously, I'll tell you that. I want to check one thing. If you November, what time did you say, Lisa?
Judge, you said 8:30.
Is that, yeah, November 24th at 8:30. So you come with your lawyer then, ma'am, okay? If you retain a lawyer and he or she needs an adjournment, I don't have a problem with them filing an appearance and we'll schedule it real quick. Otherwise, either way, you're to be here on the 24th unless I adjourn it. Do you understand that? I think she needs to think about sobriety, court counsel.
Yes, sir.
I mean, look at this record. It's like a who's who of convictions. 1, 2. You've had a lot of criminal contacts. That's what I'll do. You leave it on the hall, get your notice. We'll see you back here. Best of luck. Which other one do you have ready, counsel? Hawk? Dustin Hawk. Dustin Lee Hawk, 25W375118.
Now we're going to like the law, Mr. Huff. We'll start stationing you ready. Dustin Lee Hawk.
All right. So defendant pled guilty to disorderly. The R&O was dismissed. I love this. And I pick up the file and the first words I hear read him saying, y'all get effed to the police. Nice. You don't respect police either, huh? Well, why would you say such a thing? If I do something wrong right now, you're going to tell me to go get effed? Then don't do it with them. What do you do for a living?
Construction.
Lack of respect that we have in the society. Lack of respect. Everybody knows everything, thinks they can say whatever they want. Go ahead. What do you want to tell me, counsel?
Your Honor, my client deeply regrets his behavior that day. The bad day was not his best day. He asked the court not judge him particularly. He said, he won't do it again, Your Honor. He's learned this lesson. I know you hear it a lot, but my client sincerely would tell the court he won't be able to do this type of thing again. He's embarrassed. He just wants to put this behind him, Your Honor, and keep moving forward.
You got, how much did you have to drink that day?
I was actually arguing with my wife is what
I didn't ask you.
why I was upset with.
How much did you have to drink that day?
Not much.
Do you want me to guess what not much is? I mean, it could mean like one sip of this, or some people's ideas. I had 48 ounces. I mean, of booze. How many is a few?
Two 2x4s.
You got 2 drunk drivings on your record. and you got a drug charge. Now, granted, those were a few years ago. I'll grant you that, but I just don't go for people talking to police officers like this. I don't go for people talking to anybody like that. That's ridiculous. I mean, what did he do other than his job? Did he do anything mean to you? Did he treat you disrespectfully?
No, sir.
You just wanted to go tell him to go get effed.
No, I did. I knew I had warrants and I stepped out of the vehicle. I was like, yeah, well, here, you state me.
Again, my client had a few drinks. He was frustrated with his argument with his wife at home. He had some displaced anger and he knows he was wrong.
I don't get it. I just don't understand it. So his argument with his wife causes him to treat the police like they're nothing short of, I don't even want to use the word.
It was not an excuse, Your Honor. It's just kind of what happened that day.
I get it.
Not his best day.
I get it. Anything else?
No, Your Honor.
Anything else? 200 fines, 125 costs, 75 victims' rights fee, $50 justice assessment. 3 days on the court work program. There's $105 a day, $35 a day charge for that. So you actually spent one night in jail, true?
I spent 3 nights in jail, sir.
When were you arraigned on this?
A month ago.
You mean you were taken into custody?
Risk to the community, and whether or not he would reappear. Here, the state can point to no evidence that he wouldn't make any sort of appearance. Specifically, Your Honor, he does have medical concerns, which I think would make flight extremely difficult. More on top of that is he has demonstrated that he's willing to abide by court orders. He hasn't had contact with anyone in this for a period of over a year, according to my calculation. His father's here. He described to me this week and today, my client's on disability, does not have a lot of money. Specifically, as far as his disability, he has to maintain specific doctor's appointments to look at both his medical condition as far as his cancer, as well as numerous other conditions he has. He's not making those appointments. In this situation, Your Honor, I do believe the court has an ability to fashion bond outside of incarceration that would necessitate his appearance to court on top of the fact of maintaining safety to the community, which I would argue the state is not going to be able to demonstrate any evidence to show that any of these are at jeopardy besides the allegations, which at this point in time he's presumed innocent of. I do believe that the $150,000, as you can see, he is not able to make, would be tantamount to no bond given that he's on disability. So we would ask, there's obviously an ability for house arrest, an ability to locate and track his movement, as well as continue what he has been doing for over a year, maintain no contact with any individual here and anyone on really his family besides his father. So we'd ask the court take that into consideration. I do believe that the court in this posture does have an ability to make sure the community is safe and that he will reappear to court. And we would ask the court take that into consideration.
So Goodyear, anything on behalf of the state or on behalf of the victim?
Yes, Your Honor. I would like to speak, and Judge the victim who is here would like to speak as well.
Okay, who's talking first? Good morning, ma'am.
Hi, my name is Celeste Vanover. Your Honor, thank you for allowing me to speak. I am the mother and the victim in this case involving Danny Vanover. I'm here today to strongly oppose his release before trial. Your Honor, the danger he possesses is immediate and serious. The last time he had any contact with our children, he broke a metal cane over our son, and I stopped him from gaining access to a gun, saying he wanted to, quote, shoot that motherfucker. Afterward,
So ma'am, I apologize for interrupting you, but was that the domestic violence incident that came out of the Lebanon Municipal Court?
Yes, sir.
Okay, go ahead.
Afterward, he posted on social media that he didn't want to kill our son, but instead have our son kill him, thus showing himself to be both suicidal and homicidal. He pled guilty to these charges. These are not just words, they are clear warnings of what he is capable of. I generally fear that if he's released, he will attempt to harm me, our children, or someone else's children. My children have used the words terrified, distraught, and feel unsafe. Prior to him being arrested for this case, I've had 2 reported male intruders on our property late at night, and I do not believe this to be coincidental. I do not believe that any bond conditions could keep us safe. Since his arrest, my children and I have finally begun to feel a small measure of safety. They still live in fear and trauma from what they received and witnessed, and the thought of his release has already caused them great distress. I understand the court must consider the defendant's rights, but I respectfully ask that you also consider the safety of the victims and the community. Based on his past violence, his threats, and his unstable mental state, I truly believe he remains a danger to us all.
The intruders on the property, ma'am, when did that happen?
It was prior, Lebanon has the reports. It was 2 events, and they were October and like late September of prior to.
So they were before the domestic violence in Lebanon Municipal Court or after the domestic?
They were after that.
Okay.
Prior to indictment.
Prior to indictment, yes.
Okay. Thank you, ma'am.
Thank you.
Mr. Goodyear?
Your Honor, first let me say that, as you know, the defense been indicted for felony 1 rape, felony 2 felonious assault, and felony 4 gross sexual imposition. We have 3 separate victims that have come forward and indicated that he abused them over a long period of time. So you have 3 separate family members who are coming forward to say this happened to them. I don't think, Judge, from my perspective, from the state's perspective, I don't think $150,000 cash or surety is an unreasonable bond considering the nature of those charges. The allegations, Judge, are that he injured his son with a hot blowtorch by searing his arm during a time when he was angry. The allegation regarding the rape is that he forced his wife, Ms. Vanderbilt, just here, to engage in sexual conduct with him. And then the gross sexual position involves his stepdaughter. And she indicates that he forced himself on her while she was in the shower. I can tell you certainly, having spoken with all 3 of these victims, they are all terrified of the defendant. And I know that they, as she said, they strongly oppose his release. Judge, talking about, it's not just the safety of the community, that's of course an issue, but the safety of the victims, more particularly in this case, I think the court should consider. And one thing that I know we talked about briefly in chambers, one thing that also concerns me is he has a violent offense on his record. He was convicted of domestic violence, as we talked about. And now he's facing very serious consequences involving family members. So the domestic violence was not Celeste or the other 2 family members. It's a different son that he was involved in domestic violence with. And then we have 3 other family members that are the victims in this case. So I have serious concerns about whether, and I understand he can be on GPS monitor, but a GPS monitor doesn't stop anybody from going anywhere. It notifies you he's violating his rules, but he has the ability to access people even on a monitor. So I have serious concerns about whether he would take some type of action against these family members who are victims. And I do think, Judge, it's relevant to consider the fact that he has portrayed falsely to his attorney his condition and his treatment at the jail. As you know, I provided the court this morning with a letter from the jail detailing how he's been treated and what has been happening there. And I do have a video here, Judge, which it's literally maybe 5 or 6 seconds. I can show you, if I could, clip of this.
We have the ability to do that? Oh, good.
Yes. So Judge, if you look right here where the cursor is, that's Mr. Vanover on a, okay, that's Mr. Vanover sitting on the bottom bunk, and this is the restroom for the facility. Now you saw in the motion that was filed, and you heard Mr. Mormon say this morning that somehow Mr. Vanover is forced to sit in his own excrement, that he isn't receiving any help. He doesn't have the ability to be dealt with in the jail. What you saw is Mr. Vanover having absolutely zero problem moving from his bed to the bathroom. And there's two videos with a lot of footage showing him moving around with no problem in the jail. I show you that clip only to say that I think it's important for the court to consider that if he's willing to give his attorney a false impression of what's going on in an attempt to get out of jail, that's something I think that should concern this court, and something I think you should take into account as to whether this is an appropriate bond. But as I said,
Mr. Goodyear, why was he indicted in September of 25?
Why was he indicted September of 25?
Yes, right? I mean, that's the date of the indictment, right? September 25?
Yes.
Why was he indicted in September of 25 and not August of 25 or October of 24, November of 24? Why wasn't he indicted sooner if the state had concerns about his danger to the victims in the community?
Well, Judge, I think that, well, first of all, the indictment happened when it did because that's when the process was followed to get to the point of indictment. I generally sit down and meet with victims before we present an indictment on a case like this to get a sense of what they have to say and assess for myself the evidence we have against them before I present a case to grand jury. That, of course, takes time. There was a police investigation that took place before I myself had a chance to speak with the victims. That, of course, takes time as well. But, Judge, I guess, as I said in chambers, there's a major difference in the concern that exists as far as danger before the indictment and danger after the indictment, and that is the indictment. Before then, all Mr. Vanover knew is that he had been asked by Detective Benz months before about any problems with the family in this regard, and he denied anything happening. Time went on and nothing happened. So while time's going on, nothing's happening, certainly that doesn't create an additional risk to them because he has no idea that he's being considered to be indicted or what's going to happen. Well, now he's been indicted for rape, gross sexual imposition, and felonious assault, and he knows who the victims are. So the fact that he was indicted in September doesn't change the fact that the state believes that this risk exists now, because the fact that he's charged creates the risk. So I think that is why, from my perspective, there's a difference in what risk he would pose prior to the indictment versus after the indictment. But Judge, as I was saying, I think that a bond of this nature is reasonable and objectively considering the type of charges they are. I think the fact that he's provided false information to the attorney is a concern as to what his motivation is, to why he wants to get out. And I think that the statement given by the victim is very powerful, the fact that they're very concerned if he were to be released. So we'd ask the court to maintain the bond.
So here's where I'm at. I don't know what to believe about all of this jail business. I mean, I trust the jail to take care of Mr. Vanover while he's there. That's not really a concern of mine. I do find the concerns of the victim to be very compelling in this case. We have delayed disclosure allegations that are at least, the most recent of the allegations are more than a year old. They came out, there wasn't any problem between October of 24 and the indictment in 25. The defendant is presumed to be innocent in the case, but I am not going to grant him an OR bond. I am going to modify the bond to order that he be released on a bond in the amount of $50,000, cash surety, or 10%. He is also to be supervised on electronically monitored house arrest. That means if you are released, Mr. Vanover, you are not allowed to go anywhere except home, court, and to see your attorney, and all of those need to be set up in advance so that the victims know when it is that you would be leaving your house and for what purpose. If there are any need for medical appointments, those need to be made in advance so that the victims also are aware anytime Mr. Vanover is going to leave his house well in advance of that happening. What are we setting this for?
Your Honor, if I could ask for one more pre-trial, I did send over, actually it was in a prior case I've had in this court, a protective order. I'd like to have a chance to review that before I set it for trial.
All right, two weeks?
That should be fine.
All right, let's get back on for a pretrial in 2 weeks. Anything else?
No, sir. Thank you, Judge.
All right, that's all.
Custody on April 1 or just on the failures to appear? Were you taken into custody the night of the offense?
Yes.
And you're telling me you spent 3 nights in jail there? On this case? On this case, you didn't arraign you then.
Took me from here to Southgate.
Well, you took over here to Southgate. I'm talking on this case.
I just been the weekend in jail. I got a month ago.
On this case? And you tell me you spent what days in jail?
We're here today for pretrial. It's my understanding Mr. Hood's going to be entering a plea of guilty to 1 count of breaking and entering and 1 count of criminal damaging. And we're going to set this for a sentencing and a contested restitution hearing. Is that accurately stated?
That's correct, John.
Yes, Your Honor.
Mr. Hood, how old are you?
28, sir.
How far did you go in school?
I graduated high school. I got through Scarlet Oaks. I went there for my vocational academy. I was there for about 3 years.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you, don't know enough about this case yet. What I'm going to do is set it for sentencing. It's going to take place in about 6 to 8 weeks. We're going to do a level 2 pre-sentence investigation. This is the kind of case where I'm going to put you into my community control program, but we still have some issues that need to be resolved in the case. The state is still alleging that you took stuff that didn't belong to you and they want restitution for that. It is sort of part and parcel to the breaking and entering that you are entering a plea of guilty to. So I am going to make a determination as to who this stuff belonged to, these tools. So even though you're not pleading guilty to a theft, if ultimately I determine that you took these things, then I'm going to order restitution. Doesn't mean that you're going to be convicted of the theft or that comes back alive. It just means that you're going to have to pay that money back. Do you understand all of that?
Yes, Judge.
Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, Judge.
I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Hinkle before you signed it?
Yes, I did.
Are you satisfied with the representation you've
I
received
am.
in the case? You're going to enter a plea of guilty to 1 count of breaking and entering. It's 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your supervision, and I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. There's also a criminal damaging, which is a 2nd-degree misdemeanor punishable by up to 90 days in jail. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Judge.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to counts 1 and 3, that on or about April 10th of 2025 in Deerfield Township, Warren County, Ohio, defendant David Hood trespassed into to a business to commit a theft offense. Specifically, he was a former employee of Landon Motors. He was going into the building to retrieve tools. He was positively identified by surveillance video. He gained access to the building by entering through a side window, damaged a table in the process, opened a garage door to the vehicle repair building, loaded tools and other items into his vehicle. He had been terminated by the company several weeks prior. Table belonging to the business was damaged. Tools were taken in the process of this.
Any on those facts, Ms. Hinkle?
Just that my client states that the only tools that were taken were his own, but we would stipulate to the rest of the facts.
Mr. Hood, did you hear those facts?
I did.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yeah.
Which plea?
Good.
Based upon the plea of guilty, I'm going to find you guilty. I think you've made a knowing, voluntary, and intelligent choice here today. Only if you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. You're going to go back down to pretrial, fill out the paperwork for the PSI. See everybody back here in about 8 weeks. Ms. Hinkle, go ahead and set this for a half-hour sentencing because we're going to have some issues regarding restitution and regarding the motion to modify the bail. So I don't care if you're going to come up positive for marijuana. That doesn't matter to me. So I'm not going to approve it, but I'm also not going to violate you if you test positive for weed. Okay? All right, that's all.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Monday.
Friday to Monday?
Yeah, Friday, 8 o'clock tonight until Monday morning.
All right. 4 days jail credit for it. Good or not? But you're still going to pay 200 in fines, 125 costs, 75 victim rights fee, $50 justice assessment, and 40 in attorney fees. So your total here amounts to 3 1/4, 450, 490, or 90 days. Stop treating police officers like that, will you please?
Yes, sir.
You have all this to pay?
My client can't pay this all day. He can pay 400 today. Give me 2 weeks, he can pay the balance.
Pay 400 today, balance by December 1. If you need more time, call the court. We'll go on Zoom. I'll be happy to give you an extension, okay?
Thank you, sir.
I hope you'll apologize to that officer if you see him. Alicia Marie Craig, 25WH38685, A and B.
Morning, Your Honor. Mike Hill Crawford, representing Mrs. Craig, is approaching.
All right, counsel, good morning. Your appearance, ma'am?
It's Craig Station after the record.
Hi, good morning, Alicia.
I forgot. Who owns this car? Did we talk about that before? Do you own this vehicle?
I don't.
Who owns it?
My brother.
That you were driving?
Yes, sir.
You have your proof of AA attendance?
I didn't bring it today. I didn't bring it today.
Where do you
I
live?
have it, sir. Yes, I do.
Why didn't you get it?
I've been bringing it to everyone.
Go get it.
I don't know why.
Go get it. You're gonna come back with it?
Yes, sir.
Okay, go get your AA attendance. Thank you. Do you have any others in here ready to go?
Yes. Yeah.
People against Thomas Edward Gannis III. 25W840330 A and B.
Good morning, Your Honor. Mike Hill Crawford, representing the defendant who's approaching.
Your name, sir?
Thomas Gannon, the third guy.
He's never been arraigned. He's charged with driveway license not valid. And he also has another charge of no proof of insurance. So for purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
All right, so I'm entering a not guilty plea on that charge and a plea of denial on the no proof. And then as I understand it, he's going to plead guilty to allowing an unlicensed driver to drive. The prosecutor is going to then move to dismiss the driving while invalid. And the prosecutor will also just move to dismiss the driving without proof of insurance. True?
True, Your Honor.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead to that, allowing a licensed driver to drive, The possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights and read and understand the rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing nor a trial. Do you understand that?
Yes, Your Honor.
Any questions before I ask you how you plead?
No, Your Honor.
The charge, allowing unlicensed driver to drive, how do you plead?
Guilty, Your Honor.
Were you in control of a motor vehicle that was being operated on October 18 to 25 on Allen near Carter and Woodhaven at roughly 8:49 p.m.?
Yes, Your Honor.
And that was a 2012 Dodge, correct?
Yes, Your Honor.
And was your license suspended or revoked or denied?
Yes, sir.
And,
It was suspended.
and you knew that, right?
No, sir. I was under the impression that I took 2 classes to fix it. I didn't realize I had to have my stepfather who lives in Florida right now to go to the state for me. So at the moment, I had no idea, sir. Or I would not be anymore involved in the I had to take 2 driving classes for the state of Florida itself. So I am just out here for contract work for my father. And that's why the car's not my name.
Are you on probation or parole?
No, sir.
But you were suspended, correct?
Just my license, yes, sir.
Well, I know that, but anybody force you to plead guilty?
No, sir.
Right.
I'm no, sir. I'm assuming I'm just pleading guilty to the one where it's the
Yeah, just
second one we just talked about, correct?
allowing unlicensed driver to drive.
Yes, sir.
And they're dismissing the suspend.
Yes, sir.
And they're dismissing the no proof.
Yes,
And that's your understanding.
yes, sir.
All right, I'm accepting your plea to allowing unlicensed driver to drive. The no proof and suspend or drive while license not valid or dismissed. Anything you'd like to say? Does he have a valid license now?
He does, Your Honor. Insurance is in place and everything. He's good to go.
All right. Sir, anything you'd like to say?
Thank you, Your Honor, for helping me out.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 60 days. You can go down the hall and pay that.
He's gonna take that.
And you're all set. Good luck.
Thank you, Your Honor. Thank you.
All right. Do you have any others? Do you have Paulovino?
One more.
Paulovino.
This is Palomino.
People against Amy Lynn Paulovino, file number 25W840101.
The Lord and Your Honor, Michael Crawford representing Ms. Palomino, who's approaching.
Okay, ma'am, your name?
Amy Palmino.
So this can be a plea to failure to stop assured clear distance.
Correct, Your Honor.
And they're going to dismiss the leaving the scene, right?
Correct.
And what does it say? Defendant's physician grinding? I can't.
Well, Your Honor.
I can't read it. Is all I'm trying to say on the bottom here.
My client is suffering from cognitive issues, and there was a doctor's letter to that effect. That's kind of the underlying issue here. And also to let the court know that she won't be driving anytime in the near future. She's just clearing from the doctor.
I just can't read that. Defendant's physician, something he's from driving.
Yeah, the doctor is saying she shouldn't drive until it's further tested.
All right. Okay, ma'am, you understand what your lawyers worked out?
Yeah, I'm responsible.
You understand this is 2 points, failure to stop assured clear distance and the leaving the scene will be dismissed? Yes?
Yes.
I don't know what this has to do with any medical condition of leaving the scene. The failure to stop assured clear distance has something to do with that. She had no business leaving the scene. You understand that's 2 points. They're being awful nice to you. Do you understand that? Do you understand that?
Yes.
To the charge, failure to stop assured clear distance, responsible or not responsible?
What is that?
Do you plead responsible, ma'am?
Yes, responsible.
I'll accept the plea, dismiss the leave the scene, 225. You can go down the hall and take care of that and you're all set. Good luck. Please be careful, ma'am. You gotta stop. You gotta stop. Anthony Joseph LaFord the second, 25W40437. Is Mr. LaFord here? I don't know what this, he just sent in Lieutenant, can you please?
Yes.
I don't know, was there an Anthony LaFord? Was this supposed to be a failure to appear or what? Can you take this back to him? Just ask him here. We'll hand it to you right there. Thanks. People against Gaddy, Timothy Michael Gaddy. 25WA399929. Well, I mean, I don't know what to do with them on this one. I mean, if we schedule this and reschedule this, I set a formal. We set it over to November 12th. Defendant failed to appear. He is responsible as charged by default. Defendant is responsible as charged by default. All right. I don't know where's her file now? What case do you have, Ms. Royals? I called your case a time or two, but.
Yeah, good morning, Your Honor. I have a Dolly Wall. I'm sorry, I was in person on record.
We did with that. You have it over there, John? I probably just put it. Yeah. Put it aside here. What are you here on?
Dolly Wall?
Judge, the file got brought down to my office if John wants to run down and grab it.
Got to go down there and get it, Jim. Rodney Dean Miracle, 25WA38504. 24WA34355. A and B. Your name?
Rodney Dean Miracle.
Did you meet with the prosecutor?
Yes.
You waived your right to a lawyer, true?
Yes.
You're going to plead on this 50 says, I just want to make sure we're understanding one another. Says you're going to plead guilty on this 504 file, the driving on a suspended. They then are going to dismiss 355A, right?
Right.
And then this judgment will remain in effect on the 355B. You understand that?
Yes.
You plead on 504. Possible penalties are up to 500 fines, 93 days jail, costs are all those. Once you plead to that, I'm going to dismiss the 55A file. Do you understand that?
Yes.
All right. If you plead guilty here to driving on a suspended or drive while license not valid, again, the possible penalties up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
All right. Did you sign, read, and understand an advice or rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
You have the right to a lawyer. If you want one, I will give you one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No.
To the charge driving on a suspended on file 838504, how do you plead?
Yes.
Were you operating a motor vehicle on Hall near West and Woodhaven, October 26 to 25 at 3:35 in the morning?
Yes.
Was your license suspended?
Yes.
Are you on probation or parole? Anybody forced you to plead guilty?
No.
Plea is accepted on 504. The plea is the suspend charge on 355A is dismissed pursuant to stipulation, and you still have an outstanding judgment on 355B. You're aware of that, right?
I'm not sure what that means.
Well, you didn't pay. Is your girlfriend, you get a hold of your girlfriend?
Oh, no, I didn't know you mentioned be here today.
Well, I got it. I can't apply the bond unless we hear from you. Her.
Okay.
Amy, what do I have to ever do? Call the court?
Yeah, usually we'll have them send up their driver's license. We need some sort of proof that we're talking to her. So she either needs to come in or call the court, and then we'll tell her what she needs to do as far as send up her driver's license, like a picture of her driver's license.
Where's she at now?
She's at work.
Can you get a hold of her?
Yeah.
Or else you can just pay this if whatever you want.
How much is that?
Well, you owe $213 on that case. And I'm going to sentence you on the new one, but I can give you time to pay it on that.
Yeah, I mean, if we can,
When are you going to get a valid license?
I've been working on it.
What do you mean working on it? What have you been doing to work on it?
What was that?
What have you been doing to work on it? You have a Warrant out of the 25th, the 36th, the 36th, the 36th, the 27th, and the 27th. You don't like to show up in court?
I paid all my, well, I got a lot of tickets, like a couple thousand worth, paid them all off twice. But when you pay them off, you're still not able to drive to a certain amount, so then I've got pulled over.
You gotta stop doing this, son.
Yeah.
100 fines, 300 costs, 75 victims' rights, $50 justice assessment. On 504, it's 4 1/4 or 90 days, okay?
Yeah.
Now, how much do you
Represented by Mr. Clark, and we have Mr. View from the prosecutor's office. We are here today for pretrial. It's my understanding Mr. Dickershide's going to enter a plea of guilty to 1 count of breaking and entering. Is that accurately stated?
Yes, Your Honor.
Mr. Dickershide, how old are you?
46.
How far did you go in school?
GED.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. I'm going to set this for sentencing in about 6 to 8 weeks. I'm going to do a level 2 pre-sentence investigation, and we're going to come back here. Then it is a part of the plea bargain that the state agrees not to recommend additional jail time, and that they are in agreement with me placing you into my community control program, which is sort of what I do for a case like this. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Clark before you signed it?
Yes.
I know we've had some issues in this regard, but are you satisfied with the representation that you have received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of breaking and entering. This is a 5th-degree felony. It's punishable by up to 12 months in prison and a $2,500 fine. If you were to violate the terms of a community control and I sent you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. It does seem like I am going to put you into my community control program. That's what most people think of as probation. That means I would give you rules to live by, and if you don't follow those rules, I can change them, I can make them tougher, I can extend the time that you're on community control up to 5 years. Might include time in the local jail or in some sort of treatment facility. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf. You have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on June the 14th of 2025 at a location in Turtle Creek Township, Warren County, state of Ohio, that the defendant by force or stealth did trespass upon the real property of American Tower and an unoccupied structure with the purpose to commit a theft offense.
We do have the issue of restitution, which we don't know how much that's going to be, right?
Correct. Ms. Bernard is working on getting a final number for restitution on.
All right. Mr. Clark, anything on those facts?
Nothing on the facts, Your Honor.
Mr. Dickerside, did you hear those facts?
Yes.
Do you understand the rights that you're giving up by entering a plea of guilty to this charge?
Yes.
Is this what you want to do?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. Need to go back down to pretrial, fill out the paperwork for the PSI. We'll see everybody back here in about 8 weeks.
Your Honor, on Monday, I did forward to the court a court order for GPS information from Butler County Sheriff's Office. If you have not signed that, I assume we don't need to do that. I'll just notify them that we've resolved the case.
Okay.
Your Honor, if I could speak in that matter, just because.
Don't think that I've signed it yet.
I think it was sent late on Monday, so I don't believe that it's been filed. So, I mean, I know my motion has been filed and forwarded, but I don't think the order has been signed.
Okay. I remember seeing it because I remember thinking, I don't know if I have the ability to do this, but it's moot point now.
Okay.
Okay? All right.
Just for clarification, even if you don't sign it, Mr. Dickershide can do the exact same thing. He can request these documents, correct?
That is my understanding, and speaking with Officer Shackelford, is that Officer Shackelford had already informed Mr. Dickershide that if he wanted that information, that he could request it and get it from them.
Okay. Well, it doesn't sound like it's part of my case anymore, so.
It is being requested by that officer that I have it subpoenaed. They won't give it to me. I've asked numerous times, they wouldn't give it to me. That's why when the prosecutor did request it in the case, it was something that was cool with me because they wouldn't give it to me. They said it would have to be subpoenaed by the court.
But what difference does it make now that the case is over? Well,
just because I just want to gather all the evidence and all the transcripts that was available. If it was subpoenaed by the prosecutor, I would like it to continue to be subpoenaed for me to have a copy of it if I could, please.
We did not issue a subpoena. My understanding is that they needed a court order, but what the officer told me is that he informed Mr. Dickershide that Mr. Dickershide could make a request. Maybe it was a Freedom of Information Act or request to get copies of his own GPS points. So I can't speak to their process or other than what Officer Shackelford, represented to me.
so you're saying, Mr. Dickershide, that you still want this information to be collected?
Yes, please.
Given that, Mr. View, is there any reason for me not to sign the order and have them send me the information?
I think that's fine. I believe Officer Shackelford, based on Mike, is expecting the order to come, and he said they would try to respond to it quickly to get it to us. So,
okay. Yeah, I think my initial concern is that this was information that was that I would be issuing an order to another court to do something. But now that I think about it, community corrections is part of the sheriff's office, not the court in Butler County.
Correct.
So I don't have that issue. So I'll go ahead and sign the order. And
thank you.
We'll get it taken care of.
Thank you.
All right. Anything else?
Nothing further.
All right. That's all. Would we prefer to wait on our early terminations, Mr. View, or are we ready to go forward?
Is Page's case out?
It is.
Does Miss Page have a person?
I don't know.
Oh, well, we'll find out.
Anything on that?
Nothing additional, Your Honor. Thank you.
All right, the court will grant the early termination for Jesse Adams. Next is the case of the state of Ohio versus Owen Calendar Bastida. Case number 23 CR 41137. Present before the court is Mr. View on behalf of the prosecutor's office. Any objection or anything on the Calendar Bastida case?
My understanding is he's completed his ILC conditions, Your Honor. That we had no other addition. I mean, It looks like there were some misdemeanor assault charges. Is that right?
Right. I'm going to agree to early termination. There was a part of the plea agreement that this case not be sealed, but that's not why we're here today. So I am going to go ahead and grant the early termination.
Okay.
Next is the case of the state of Ohio versus Brian Hamilton. This is case number 24 CR 41573. We are here today for an early termination hearing. Mr. View, anything on Mr. Hamilton's case?
No, Your Honor.
All right, the court is going to grant the early termination of Mr. Hamilton's case, and that's it, right?
That's all I have.
All right, we're crushing it. We're in recess.
Big mystery of this law. Court does call the case. People versus Jacqueline Murray. Oh, okay.
She's a guest of the county, Judge, so. Pardon? She's a guest of the county.
Wow.
Right?
Yes, she is. What's wrong, Miss Perry? What? What? I guess is again.
It's an unconsensual guess.
But still, you know, still a guest.
You don't know that.
You know?
Well.
Something's good out of control. Since she didn't hear it before, the court does call the case people versus Jacqueline Murray.
Good morning, Judge Carbondale on behalf of Miss Murray. The record?
Jacqueline Murray.
Hello, Miss Murray.
All right, good morning, Judge. We are here for a supplemental sentencing. Previously, we were here before the case, before the court. This was supposed to be part of a global resolution involving a 15th district shoplifting case as well. Unfortunately, at the time, we somehow all missed the fact that there was restitution as part of the plea offer in this case. So we are, there is an amended supplemental sentencing. I have gone over the report with Ms. Murray. Basically, the only thing we're adding is a restitution, $751 on and 85 cents on this case, and then $529.72 on the 15th district case ending in 25-0021.
All right. And all right. And Ms. Murray, you have, since this is a supplemental sentencing, you have anything else you want to say?
No, Your Honor.
All right. And you don't have any objection to?
No, Your Honor.
All right, very good. $125 statutory fee, $751.85 restitution to Target payable through the court. That's this court, 14A. Then $529.72 restitution to Aldi for the 15th district court case. That's payable through the court. So there are two restitutions. One's payable here, the other's payable in the city of Ann Arbor.
Okay.
All right. I'll order 365 days in jail, credit 185 days, balance suspended. I think now, Ms. Murray, you don't have to see me again.
I think I'll see you like next month.
She's got a case with Mr. Drukas on another matter. I think it's her last
You
one,
just
right?
need to stop. Okay, we'll see you next month then. I thought you were done with me. All right.
Thank you, Judge.
Court calls the case of the people versus Jennifer Gray.
Assistant Public Defender Natalie Pate with, or on behalf of, but I do not believe with Ms. Gray, Your Honor. Since the last hearing, Your Honor did adjourn to today's date, even though she did not appear
Yes,
at
it
the
did.
previous sentencing date. I have again reached out to her, left voicemails. I have not heard back, and she has not reached out to me or my office, from my understanding. Frankly, I don't have an explanation for her failure to appear, and I certainly hope she's okay, but I would be requesting an adjournment for the record.
I'm Teresa Claire on behalf of probation, Your Honor. Ms. Gray did not appear at the last hearing. This is the second time. I did request the court to adjourn the last one, given that she's
You
not.
did.
I did.
You did.
Um,
Against my better judgment.
yes.
And see, this is where we are. No, go ahead. I'm sorry.
But given that she is not here again today, Your Honor, I would request that the court issue a bench warrant.
Bench warrant for defendant's failure to appear. Bond will be set anyway at $10,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Sherry Walker. Oh, boy. Here we go. Morning, Ms. Walker.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Walker in the case ending in 0938.
And yes, Your Honor, Brandon Bird on behalf of Shay Walker in 0865. Ms. Walker, can you please take your correct?
Sherry Ann Walker. All right, very good. All right, go ahead, guy.
Thank you, Your Honor. Today's the date and time set for sentencing in both cases. As to my case, I've reviewed the report with Ms. Walker, and we do not have any changes or corrections, and we would be asking the court to adopt probation's recommendation.
And yes, Your Honor, I did get a chance to go over the pre-sentence investigation report with Ms. Walker. No additions or corrections, and we do ask to stick with the recommendation of the probation department, Your Honor.
All right. Ms. Walker, anything you want to say?
I'm just glad that this took care of, and hopefully I make a difference in my future.
I believe it's going to be more than hopefully, Your Honor, because I do get a lot of time to talk with Ms. Walker. We get a lot of talk time, and she seems like she really wants to make a change in her life.
I do.
You know, I remember everything. So if you come back on, I'm going to remember.
Oh, yeah.
All right. I'm not going to blame you. I'm going to blame him. All right. Not Miss Pate. Miss Pate's having a day.
Ms. Walker wouldn't want me blamed either.
Yeah. All right. In the case ending in 0938, sentence of the court, $125 fine to court costs, 93 days in jail, credit 93 served. In the other matter, $125 state fee, 114 days in jail, credit 114 served.
Thank you.
All right. Thank you. And Ms. Walker, good luck to you in the future.
Thank you.
Appreciate it.
Thank you, Your Honor, and you and the Honorable Court have a great day.
That's it for you?
That's it for me, Your Honor.
Really?
Really.
People have to let me, so Mr. Allen said that you sneak into the courtroom and sit places. We can't do what Mr. Allen said we should do, and that was put a beller on your neck.
Oh,
Don't you remember the conversation? Okay. Sorry, may have been somebody, it might have been somebody else. I'm sorry, my bad. All right, take care. I thought that's what you said, man. I'm hearing things. Court calls the case, People versus Victoria Heights.
Good morning. This is the public defender on behalf of Ms. Heights. Sorry. Ms. Height, state your name for the record, please.
Victoria Height.
Thank you.
Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report. Do not have any material changes, additions, or deletions. We ask that you adopt the sentence recommendation.
Height, is there anything you'd like to tell the court before I impose sentence?
No, sir.
All right. Sentence of the court, 12 months probation. Fines and costs of $500, $360 probation oversight fees, $1,893.08 restitution to Walmart payable through the court. How are you intending on getting that paid, ma'am?
I can pay $400 today, and then I'd like to set up a payment plan.
Do you have the $400 in cash?
Yes.
All right. So $400, that will go toward the restitution. And in terms of a payment plan, what are you thinking?
Well, I'm in the process of getting a loan out, so I should be able to pay in full within a month. So any payment plan is fine at this point.
I'll note that for the record, but I'll have a payment plan as arranged by probation to get that paid. If you're going to pay in 30 days, I'd suggest that you do that. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual therapy with proof through probation. Complete 25 hours of community service as directed by probation. No going to any Walmart store within the state of Michigan. Although there are 365 days in jail, credit 1, the balance is suspended.
Thank you.
Are you sure?
No, I'm sure. When you go make your payment at the clerk's office.
I think it's over a period. Court calls the case, People versus Savannah Bradley.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Bradley. Ms. Bradley, state your name for the record.
Savannah Bradley.
All right.
Your Honor, today's the date and time set for sentencing. We did review the pre-sentence report and don't have any material changes, additions, or deletions, and we ask that you adopt the sentence recommendation.
Anything you want to say before I do impose sentence?
No.
All right. On the count one, controlled substance use, 18 months probation, $555 fines and court costs, $540 probation, oversight fees. How do you think you're going to get that paid?
I'm gonna get a job. As soon as I get out.
She's been in custody
That'd be a payment plan as arranged by probation.
a month, I think, at this point.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a substance abuse assessment, comply with all treatment recommendations with status reports to probation. You're to obtain your GED with verification to probation. You're to maintain employment with proof to probation. You're to report to probation on Tuesday, November 18, 2025 at 11 a.m. That's an in-person reporting. And then you're to report to probation as directed. I will order 365 days in jail, credit 26. The balance is suspended. On count three, retail fraud, 18 months probation, $480 fines and court costs. That again is as paid with a payment plan through probation. You're to complete a theft class as directed by probation. You're to complete 25 hours of community service. No going to any Target store in the state of Michigan. You're to comply with all terms as set forth in count one. I'll order 93 days in jail, credit 26. The balance is suspended. Thank you.
Thank you.
Thank you.
See that? No. Okay. Court calls the case of the people versus Jason Holdaway.
Good morning, Assistant Public Defender on behalf of Ms. Holdaway.
No.
Holdaway, state your name for the record, sir.
Jason Holdaway?
All right, there's his camera. Okay, go ahead.
Your Honor, so we have to take time set for sentencing. We do ask that you adopt the recommendation. This incident that happened, I believe, over a year ago. Immediately after Mr. Holdaway did enroll in inpatient treatment at Don Farm, he did complete that program. He has been, I believe, sober for either 10 months is coming up or 12 months. Mr. Holdaway would have to clarify. I apologize. But he's really taken some steps to change the circumstances in his life. He's been a pleasure to work with. So again, we do ask that you adopt the recommendation.
All right. Mr. Holdaway, anything you want to tell the court before I impose sentence? You're muted, sir. Nope, not yet. There you go.
All right. I was just going to say I'll be a 1-year sobriety on December 4th. So
congratulations. That's fantastic.
Thank you. Otherwise, no, nothing else, Your Honor.
You know, that's you kind of just sort of slough that off saying when your sobriety happens, but I'm going to tell you two things. One is the thought of you getting there after being a 0.31 is an amazing task and takes a lot of effort and something you should be real proud of, sir. And the other thing is, I remember people when they show up before me, and I don't know if you have any pictures of yourself when you first showed up, but if you took a picture of yourself when you first showed up and in looking at you now, you look so much better. Just
I've heard
physically better.
40 pounds on since I quit drinking.
There you go. All right. So a lot of good things happen.
Yeah.
Yep. Okay. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly, the alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I will place you on probation for a 12-month period. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can that be paid, sir?
Can I have a 90-day plan on that?
90 days?
Please.
All right, here's what I'll do. Payment plan is arranged by probation over a period of 90 days.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment with Home of New Vision, including all aftercare, recommended aftercare with status reports to probation. You're to provide proof of victims' impact panel attendance to probation. I'll continue the sober link for an additional 30 days in lieu of 2 days in jail. I'll order 93 days in jail, credit 3. The balance is suspended. All right. Thank you, sir.
Thanks, sir. Have a good afternoon.
And again, congratulations to you. Upcoming.
Thank you.
All right. Take care of yourself. Court does call the case of the people versus Nicholas Chalmers.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Chalmers. Mr. Chalmers, state your name for the record, please.
Nicholas Chalmers.
Your Honor, Mr. Chalmers is before the court for a violation of probation. Mr. Chalmers is non-compliant in that he owes $5. He's made no payment to the court. He failed to report to probation as directed, failed to complete a SPECT class, failed to complete 25 hours of community service, failed to provide proof of employment. He, Your Honor, also has bench warrants out of the 44th District Court, the 36th District Court, and the 39th District Court. He also has a pending criminal case out of Macomb County, a felony burglar tools possession with an alleged date of offense, 20th of 2025. That case as the court knows, that's a continuation of the same behavior that this case is. Given all the circumstances, probation is asking that the court revoke his probation, sentence him to 93 days in jail, credit for 19 days served, and he served the valence of that, waive his remaining terms, accept the financial obligations, and discharge him from probation without payment.
Your Honor, I did have a chance to speak with Mr. Chalmers about everything that has been going on. His mother is also here and would like an opportunity to speak to the court if the court is amenable to that. Regarding the terms, I think Mr. Chalmers, I think the one to start off with is reporting to probation. He maintains that he was told he was non-reporting. I spoke with
that he what?
Was non-reporting. I spoke with Miss Pilara, and she indicates that she doesn't have anyone that's non-reporting.
Doesn't happen at this court, so he couldn't have been under that impression.
I explained that to Mr. Chalmers. He understands there was clearly some miscommunication. He regrets that he did not report and is willing to report moving forward.
And I'm going to let you say what you're going to say. But because you've got to represent your client's telling you that. If he's representing to you that somehow or another this court, that he was under some impression that he was non-reporting, or that somehow this could even be characterized as some type of misunderstanding, that's problematic for me because I don't believe any of that. I mean, I'm going to let you say, and I'm not, Ms. Parody, I'm not certainly holding that against you. You have a job to do. But if that's what he's having you represent, I'm not buying it.
We've had, because this was set previously and Mr. Chalmers failed to appear, we've spoken multiple times about this, and he's maintained the entire time that he thought he was non-reporting. And I do believe that was a miscommunication. I hear what the court is saying. Regarding the rest of the terms, it seems to me that he did make efforts to complete everything. So he believes that he did complete that theft class. He reports to me he did complete the community service. He did that at a soup kitchen in Ypsilanti. And he was working for the beginning of his probationary period at FedEx. He lost that job a few months ago, but his mother actually indicated to me that she spoke with FedEx and he can be reinstated to that job if he is released from custody. Mr. Chalmers is also doing some good things, I think. So he is the primary caregiver for his 5-year-old. He lives with his grandmother, who assists with taking care of his son, but he is the primary caregiver. His grandmother, his mother told me today, is a teacher at a middle school in Ann Arbor. And Mr. Chalmers also just got his GED through Washtenaw Community College and is now taking preliminary associate's classes at Wayne Community College. So he does have things that he wants to get out and take care of. He did turn himself in after he failed to appear. So he's not running from this, Your Honor. He wants to show the court that he can complete probation. I would like an opportunity to get Ms. Pilara the proof of completion of the theft class and the community service when Mr. Chalmers can provide that to me. I do think the fact that he turned himself in after he failed to appear is a big indication that he wants to resolve this matter. So given all that, I ask that the court take this into consideration. He was sentenced just back in March, so he does have time to finish up his probationary terms. I tried to look up some more details in the Macomb County case. I couldn't find it in their case search. I don't know if it was user error or what. I just want to see what stage that case is at. I'm not even sure if he's been arraigned on that case. Mr. Chalmers indicated he didn't have an attorney, so I don't have anyone to contact about that as well. So I think that one is in the very, very preliminary stages. So again, I'd ask the court take that into consideration. And then the bench warrants, Mr. Chalmers indicates to me, are mostly traffic stuff. So given all that, again, I'd ask the court to reinstate his probation, let him complete his term. He can pay $300 this week, I think you said, if he were to be released. But again, he has been out of work for a few months. And again, his mother is here and would like to add if the court is open to hearing from her.
Did he make the $200 payment in March?
Ms. Pilara has no payments made. I did not verify if there was any payments made. Do you remember paying $200?
I honestly don't.
Your Honor, there are no payments made.
That's what I thought as I'm looking at it. And just so you know, he represented to the court on that day, March 11th, that he was going to pay $200 that day.
Yeah, I frankly, Your Honor, I don't remember. I do know, as I stated, Mr. Chalmers was working, had lost work, is the primary caregiver for his child. I don't know if some kind of bill came up or something like that.
And Your Honor, I would also like the court to be aware, it looks like Mr. Chalmers also has a hold at the jail from Wayne County Sheriff for a fleeing, bond denied. I don't know if that's an additional. If that's something additional, I don't see the case. I didn't see the case when I ran his criminal history, but I do see he does have that hold.
For fleeing and eluding.
For a fleeing, bond denied, Wayne County Sheriff.
He can have a seat there. His mom wants to say something to him. State your name.
Nicole Franklin. I just want to say, he's a great kid. I don't know where all this has come from. He was shot twice and almost died 5 years ago when my grandson was just born. In the chest once and in the stomach once. They tried to rob him for his gym shoes. Ever since then, he's been a different person. We've tried to get help. It was the pandemic time. He needs help. He's a great kid. He's a great father. He's a great father. He takes care of his 5-year-old. Right now, his 5-year-old is born between me and my 78-year-old mother, which is hard. He's asking for daddy every day. Nicholas is really a great kid. Like I said, from the ordeal of him being shot, he just turns into a different person. I just need him home. And I know that's not enough for you from everything you've just heard. We need him home. I don't know what to say. I don't know.
Ma'am, you also understand that even if I were to release him today, you won't be going home. Because the last indication from Miss Flora was he's got whatever situation he's found himself in Wayne County, he's got bond denied.
I've been doing everything. I've been checking up on everything. I've called Wayne County.
Ma'am,
and
let me
they were
stop
putting
you.
him on tether.
Let me stop you. Okay. I hear you. I did not think, frankly, in this case that we would end up at this point in time, or at this point. I gave your son every break could coming into sentencing. Didn't make it a very difficult probation for him. And indicated basically that he needed to just get through it. If he represented to me on the date of the sentencing, and I just went through it, that he was going to pay $200. And it really isn't so much about the money, it's about the representation it makes to the court that he's going to do this. And I'm now here, whatever many months later, and he's paid nothing. And didn't go to probation to tell probation if he had a problem. We run into that all the time. He just had to say, I can't make this. This is what I can do right now. And he didn't do it because he wasn't going to probation. I can tell you right now, and I hesitate in doing it, but when he's telling me he thought he had non-reporting probation, if Ms. Valera pulls up his probation order, it's not going to say that. And I know it's not going to say that. And that's why I stopped Miss Parody when she was saying, because it's not true. I don't have those. Not in that way. And he knows that. And he's just, ma'am, it is hard for me to sit here and to try to tell a mother that he isn't acting and he isn't what you raised.
He's not. He's not. I didn't raise him like that.
I know you didn't. I can tell by the way that I can tell you did not raise him this way. And the problem is, he's going to have to make the decision to change his behavior. You can't do that for him. I don't know you, but I'm sure throughout his life, you have done everything within your power to give him what chances, what opportunities there are. And all he had to do was to grab onto those opportunities, pull himself up and just do the right thing. And throughout everything, he's not doing that. It also troubles me outside of all of that, that the warrant that he's got out of Macomb County is, he's here basically on a breaking and entering charge. And the warrant that he has out of Macomb County, the felony warrant, is possession of burglary tools. He's just involved in the same activities over and over again. Ma'am, far be it from me to try to tell a mother about her child. And I think you know what I mean, but I don't do that. But I'm telling you, he's lying to you. And most importantly, what angers me, particularly after hearing from you, is that the way that he's operating his life, he's disrespecting you and your mother, his grandmother. And there's a lot in life I'll tolerate, but I'm gonna tell you what, and people know this. You come in here, you disrespect your mother. If they're not gonna do something, I'm sure as heck you don't want to be before me doing that, but he's disrespecting you in every way that he can because he thinks he knows more. Was there anything else you wanted to tell me, ma'am?
His son needs him. He needs him. His son needs him. He needs him.
Thank you, ma'am.
Thank you. I love you, Nick. Love you. Love you.
Anything else you'd like to say, Ms. Barron?
Nothing from me, Your Honor. I do appreciate Ms. Franklin speaking to me and speaking to Your Honor and on behalf of Mr. Chalmers. I do think he has a very good support system.
Chalmers, is there anything you want to tell us?
Nothing I would
before
like to say.
close sentence?
No, Your Honor.
I don't know how you do that to that woman. I honestly don't understand it. I don't understand how, if you don't have enough respect for yourself, how you couldn't have enough respect for her not to do this. For God's sakes, that's your mother. Who I don't have a doubt in my mind that if it came down to it, would lay down her life for yours. And all she does is, here's all the things that you've done or not done that you're supposed to do. Still has the courage to come before the court and beg for mercy for her son. We're going to waive all remaining terms except for his financial obligations, discharge him from probation without improvement. You've got certainly bigger fish to fry in other counties, it looks like. I'm going to order 93 days in jail, give you credit for 19 days served. The balance the defendant will serve. Defendant is remanded. Court calls case People versus Jaden Patrick.
Good morning, Your Honor.
Ma'am, take care.
Thank you.
Sorry, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Patrick, who is present via Zoom. Sir, can you please unmute and state your name again for the record?
Jaden Patrick.
Thank you. Your Honor, it's my understanding that the recommendation, that Mr. Patrick did not complete his PSI and the recommendation is to re-refer him so he can get that done. I would ask that the court adopt that recommendation.
And Tris Claire on behalf of probation, that is correct, Your Honor. Mr. Patrick did not make contact with the probation department.
All right. We refer to defendant to probation for pre-sentence investigation and report. He's to pay $75 re-referral fee. He's to pay that to the court today. I'll give him a PSI appointment. That'd be November 20th, 2025 at 11 a.m. in person. Did you get that, Mr. Patrick?
Yes. Could you
November 20th.
Okay.
November 20th, 2025, 11 a.m. in person.
Okay.
I'll adjourn his sentencing to December 10th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Eric LZ Williams.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Elsie Williams. Good morning.
Morning.
State your name for the record.
Eric Cole, LZ Williams.
All right.
Your Honor, this is a show cause. Mr. Elsie Williams being held on a $50,000 bond on another case. So I just asked for an adjournment to see what happens there.
When is that up again?
You know,
The 20th.
Up in circuit court?
I think you're here.
Here, yes.
Yeah, he's before me.
Yes.
All right. I'll adjourn both of these out to December 22nd, 2025, 9 a.m.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Michael Burke. This is my recall. Hold on. I'm just checking. No, I'm just checking. Hold on.
Yes, Your Honor. Assistant Public Defender Natalie, I almost forgot my own name. Assistant Public Defender Natalie Pate on behalf of
It's
Mr.
Natalie
Burke.
Pearney.
It's close. Similar initials. Your Honor, I do thank you very much for passing the matter and allowing me to reach out to Mr. Burke. I did do so and left him a couple of voicemails and sent him some texts. I will say for the record, this is highly unusual for him and how it has been up until this point. And I know today it's set for sentencing. I will also note that per the most recent progress report that I received yesterday, he is completely compliant with his scram tether. To that end, I would ask if the court would consider an adjournment for the record, or in the alternate, any bench warrant to be issued if the court would consider holding it in abeyance for several days.
This ASM, you got the continuation narrative report. Did you get that?
Sorry, Your Honor.
The narrative report?
Yes, Your Honor. The assessment I did.
So you've heard from him or not? I mean,
Not today, Your Honor. He and I spoke on Monday, and he and I have been in constant contact. And it's my understanding this is his first failure to appear for court. And he is compliant on bond as well, to my understanding, including the alcohol testing.
but I have to also This is a second offense, although he pled to a first, it's a 2 second.
That is correct, Your Honor.
It's a 139 and there was a crash, so. He did return from Florida.
Oh, yes, Your Honor. And he has
He did?
appeared
Okay.
at least twice in court since then for both pretrial and final settlement conference.
Paid, I don't know why. Yeah, I really don't. It's so much easier just to. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give a 10% privilege on that. I won't issue the warrant till the 17th.
Thank you, Your Honor.
You better find them or I'm taking you. No, I'm talking to you. This never has happened in this page ever until you showed up. I'm just letting you know. Court calls the case, People versus Christopher Fair.
Assistant Public Defender Natalie Pate on behalf of Mr. Fair, who approaches the podium. Please state your name for the record, sir.
Christopher Fair.
Teresa Claire on behalf of probation. Your Honor, Mr. Fair is before the court for a violation of probation. Mr. Fair is not compliant with the terms ordered by this court in that he owes a balance of $960. He's made no payment. He failed to complete the theft class, failed to complete 25 hours of community service, failed to report to probation as directed. He's had multiple failure to appears before this court. 3 that just from this year. He also has a criminal conviction out of the 15th District Court for trespassing, a date of offense of July 28th of 2025. He also has pending criminal cases, one before the 1483 District Court for a retail fraud second offense with an alleged date of offense for July 8th of 2025, and before Your Honor at this court for a felony R&O, an alleged date of offense of October 29, 2025. Given that the age of this case, Your Honor, and Mr. Fair's chances that this court has given him to complete a probation term, and he is continuing to do or show this court that he's doing criminal behavior, probation is asking that the prosecutor deferred sentence he was given in this case be revoked and that the conviction enter, that the court sentence him to 90 days in jail with credit for 54 days served, that he served the balance, waive remaining terms that this court ordered, accept the financial obligations, and discharge him from probation without improvement.
Thank you, Your Honor. I was able to meet with Mr. Fair and discuss these alleged violations as well as the recommendation with him. He does not at all dispute any of the violations of probation and is apologetic to this court and does ask the court to adopt probation's recommendation.
Sir, anything you want to tell him?
No, sir.
Court is going to revoke the defendant's prosecutor deferred sentence. The conviction in this matter will enter. Waive all remaining terms, accept his financial obligations, discharge him from probation without improvement. The financial obligations will be referred to collections. I will sentence him to 90 days in jail. Credit 54 that he served. Defendant is to serve the balance. Thank you. Court does call the case of the People versus Dominique Kelly Payne.
So Public Defender Natalie Pate on behalf of is approaching. Record, sir.
Dominic Kelly Payne.
Thank you, Your Honor. This is matter set for show cause. There is still a balance. My client is currently held on other matters. It states to me that he is set to be released to treatment next week, but he's not sure exactly where he'll be released to or what treatment facility.
Probably a 30-day or.
I don't have that information. It might be.
Might be longer.
Might be longer, might be a 90. Give me my February date.
Thank you, Your Honor.
Yes.
During the matter of February 4th, 2025, 9 a.m. 2026, 9 a.m. Thank you.
Thank you, sir.
Court calls case People versus Jeremiah Sawyer.
Good morning. Assistant Public Defender Lauren Kearney on behalf of Mr. Sawyer. Mr. Sawyer, state your name for the record, please.
Jeremiah Sawyer.
All right.
Your Honor, we reviewed the pre-sentence report, don't have any changes, additions, or deletions. We ask that you adopt the recommendation. Mr. Sawyer's been in custody, I think, for 264 days as of today.
Pardon?
He's been in custody for 264 days as of today.
Does he have an anticipated release date or no?
In ex jail, well, maybe.
Go to court and go to trial in 9 days.
Oh, right, the 21st.
Yeah.
Okay. Anything you want to tell me before I impose that, sir?
No, sir. I apologize for the door, but I do want to say, I do think that the door was, I think I was the one that, exposed the fragileness of the door. I don't feel like the sole cause of that door breaking. I kicked the door like 4 times. I'm pretty skinny. I don't think I'm that strong, right? But, the door broke open. I take responsibility for it, but it's like they changed all the doors over there after that. So I think I did them a favor and exposed the door.
Gotta be kidding me.
Oh,
you did a favor? Okay. No, go ahead. You're allowed to say what you want to say.
No, I just feel like
Go for it.
that the doors was, you feel me? It wasn't me who basically it was gonna happen regardless, and they end up changing all the doors after that. So it's not like I just kicked a brand new door open. These doors are like 70 years old, man. So, y'all.
That we're clear, these are doors at the jail.
Yeah.
Yeah.
In the hole.
Yeah.
Yes, sir. That's all I'm saying, they charged me $6,000. I feel like that $6,000 they charged me is like me paying for every door in there. Like,
They are thick doors.
So as a citizen of Washington, I should be thanking you? Is that what you're telling me?
I'm not saying
Is that, you telling me I had to be thanking you for exposing something that needed to happen?
I'm just saying,
we did it?
What if a more aggressive person kicked that door open? And they wouldn't know that the door was that weak, right? And then something happened and then somebody got hurt behind.
So you're saving us all?
You never know. God working mysterious ways. That's all I'm saying.
Okay. You done?
Yeah.
Okay. Guess it's my turn now. $125 statutory fees. Yeah. Savior of the Washington County Jail. You're also going to owe $5,791 restitution to the Washington County Jail payable through the court. I'll order 93 days in jail credit, 93, sir. Thank you.
Who this gentleman is, can somebody tell me? Your name, sir?
James Robert Matsuda. Michael Coleman.
They're moving to dismiss.
Judge, if I can interrupt, Mr. Condrey should be in front of Judge Hessen.
Oh,
He's in the wrong courtroom.
okay. How do we get him over there? This gentleman that says Amy Wilhelm?
Yes, he's in then a warrant. It's a Judge Hessen case. He might want to flag down a deputy.
Flag down a deputy and you tell them, and we'll give you the sign the code if you need. I mean, the Zoom ID. Mr. McZuga, he should have been a lawyer. Prosecutor's moving to dismiss, right?
Yes,
What is it, a marijuana case?
yes.
What
Yes,
kind? Why they write a marijuana charge?
I think he was in possession. Yeah, well,
Oh, it's fentanyl.
oh,
Does he know that he's,
even where, what the drug was alleged in his possession, we did have a discussion with the prosecutor.
I need him to come in.
My client had other charges in front of Essence. This is kind of a global resolution.
I need Mr. Urick in here, please.
Yes, correct.
Thank you. So I'm curious, he's just, if he thinks it's a bad case, but he's in possession of fentanyl, which he should have been charged with a felony. Is there a basis for this or just wanting to be a early
think
Christmas?
basis is in a kind of a global resolution to his two matters.
I see.
Yes, yes.
So he pled in front of Judge Hessen on what?
Exactly.
On what?
Yes. I forget exactly that, but there was some other another possession charge. I know there was a driving while license suspended, and there was one other matter that was worked out.
All right. And Mr. Urick, your name?
William Urick, on behalf of the city of Whitehaven, Your Honor.
You moved to dismiss it's actually possession of fentanyl. You know that, right?
I did not know that, Your Honor. I was given to understand that it was possession of marijuana.
Well, no, that prints out on the computer. You got to be, all these computers, they're wonderful tools, but it's not marijuana. It says possession of fentanyl, observed walking in the road where it was dimly lit, suspected heroin / fentanyl. If you had, Mr. Crawford told me it's a global resolution with Judge Hessen. If you are comfortable still dismissing this because it pleas in front of her, that's your business. I just wanted to make sure you were aware it was fentanyl.
And I'm glad that the court is making us aware. Notwithstanding that, given the global resolution next door, Your Honor, if the court please, we would move to dismiss.
You got to stay away from this stuff, son.
Still here.
You're kind of getting, no disrespect, you're a lot younger than I am, but you're kind of getting old for this junk, aren't you?
You all right, Your Honor?
I really wish you well. Maybe you need to talk about sobriety court, case dismissed, motion to prosecutor. He still owes us money on the pedestrian violation. When's he going to pay this?
Your Honor, my client can pay $100 a month starting December 1st.
Where do you work at? Do you work?
No, I have every intention to,
I didn't ask you. Do you work?
no, I don't.
Why not? What are you're 23. Wait a minute, slow down. You're about 47. Hang on, slow down. You're 47 or 8, right?
Correct.
Why aren't you working? I mean, you're not collecting disability, are you? Are you under the influence right now? You're talking awful slow.
I'm just a little tired. I spent.
I'm tired too. We're always tired, but are you under the influence of something right now?
No, I'm not, Your Honor.
He was trying to explain to the court he's been in jail for the past 4 days.
You don't care.
Well, he hasn't slept well, so he's fatigued.
Come on. Who do you want to kid? Me?
No, Your Honor.
I want to talk to you. Do you really think you're going to fool me?
Your Honor, I'm not under the influence of anything.
Really? So you're going to be glad to take a blood test right now if I send you for that, right? Before, right?
Right.
Did you have a stroke ever?
Pardon?
Did you ever have a stroke?
No, I really wouldn't know if I had one or not, to tell you the truth.
You're under the influence of something. Why are you telling me you're not? You didn't drive here.
What's up?
Shh. You didn't drive here, did you? How'd you get here?
My cousin drove me over here with my father's vehicle that was impounded.
Are they still here?
No.
How are you going to get home?
Oh, I was hoping to get maybe a call out, or I'll just walk 2 miles home.
If I see you drive or hear you driving a vehicle out of here, listen to me. I'm gonna call the police. I'm gonna have them arrest you. I think you're under the influence of alcohol or drugs or both, probably drugs. I don't think there's any question. I'd bet my house against a cup of coffee if I got one out here. Now, I'm not taking a plea. I'm not the prosecutor. He made the decision to dismiss with you going down the hall and already pleading in front of Judge Hessen. But I'm telling you, you're gonna kill yourself. Do you have a wife or kids or anything?
My wife, she almost about to die of breast cancer and spread her bones. It was already long.
How about you? You got any kids?
3 months.
How old are they?
18, 25, 26.
Do you want to just admit to me that you're under the influence, or do you want me to have to figure it out on my own?
Your Honor, I'm not under the influence. Maybe at the moment. It's just, I'm upset now. I'm speaking about my wife. I can get that phone call any day.
I know, but
They didn't give her a time.
I know, but you're under the influence. You're talking like you're talking in slow motion. You follow me? I'm not trying to make you feel bad. You got to get off this junk. What's the pleas in front of Judge Hessen, Mr. Crawford?
I dare not try to quote it.
Well, it's got to be a drug charge, right?
Yes.
Okay, of course. It's not like having a sip of alcohol. You got 3 kids with your wife, right?
They're in Arizona at the time right now. I came back here a couple years ago to take care of my father. He had congestive heart, did that the water.
Congestive heart failure.
The water builds up around the heart.
Yeah, that's it. I mean, I'm no physician. I can't.
He's been in and out of the hospital for probably the last 4 years now. My mother, she passed away. I had a brother that actually died from an overdose.
Well, yeah, why are you still doing this stuff? I tell this to my close friends. I say, I go there, I see these people die, and they go to the funeral and see their friend in a casket, then they go out and use opiates. I mean, it's the worst. I'd rather play Russian roulette than take opiates.
Man, stress disorder too, so I mean, I understand exactly where you're coming from here. I understand everything.
You're not driving.
No, not. Sort of. My right hand back up, a serious comfort, I don't know.
I give you credit for that. Thank you. You did?
I will, yes, I did.
In what branch?
Sorry.
And here yesterday was Veterans Day. I admire anybody that served in the service. I really do. I know. I mean,
The day I graduated basic training was the first day we started dropping bombs. 2003.
I wish you well. Case is dismissed on motion of the prosecutor. You're going to pay. How much do you want him to pay?
$40 every 2 weeks, Your Honor.
You pay 40 per week, every bi-weekly. Pay 40 bi-weekly beginning December 1. If you don't have the money, you come talk to me. I won't be an ogre. I'll give you all the time you need. Mr. Bixuga. You weren't related to the councilman in any way, were you?
Yeah, he was my uncle. He passed away.
I know.
4 years ago.
I had the greatest respect for your uncle. I liked him a lot. Bill.
He's your man.
He was a good man. And I don't know, he had a heart attack up in Houghton Lake, right?
Yeah, unfortunately, they found him in a very bad way, I guess, face on water.
And his wife Josie still?
No, she's still alive, man.
Oh, you tell her I said.
They're talking to each other.
You be sure you tell her I said hi. Mr. Bixuga, try to get your life in order, will you please? Good luck to you. 40 bi-weekly beginning December 1. If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension. I do wish you well. Good luck.
Thank you, Your Honor.
Have a good day.
Judge, can we check to see why Gibraltar Jail is in our?
You here? I'm sorry, Sergeant. Besides the fact you just want to learn something, right?
He needs to unmute.
You have to unmute. I'm just kidding you.
Can you hear me now?
I can. What's going on? Why are you here?
I wanted to learn. Also, I want to do a read on the record, felony read on the record with an arraignment.
Nope, that's Judge Hessen's.
That's Judge Hessens too. I'm sorry. I should have asked you a few minutes ago, because nobody said anything to me. I apologize.
I'll scoot over there.
Good luck. Thank you.
Okay, thank you.
All right, Moran. Carrie Ruth Moran, 16W810025. Defendant failed to appear. Defendant failed to appear. Geez. For pretrial, the case has been going on since 16. Willful intent to delay. I think I can find that. Willful intent to delay adjudication. Well, really? 7,500, 10%, bond warrant to issue, bench warrant to issue, bond to be forfeited. And then on our other file, which he's only missed, this is 15W806545. I don't know what in the world this young lady's doing. I didn't. All right. Defendant failed to appear, bench warrant issue. 374 cash your surety on this. And Syed. Muhammad Abdul Jabbar Syed, 25W840196A and B. Defendant failed to appear. This is a first miss. We'll issue a show cause for requirements. So defendant failed to appear for arraignment.
One correction, and that is to the PSIR in the case ending in 0496.
Okay.
Under the summary, it states that Ms. Holly pled guilty. She actually pled no contest to the reduced charge, not guilty. Other than that, Your Honor, we have no requested changes and would, on both matters, ask that the court adopt probation's recommendation. Ms. Holly would be asking for some time to pay the fine. She does state to me that she does receive food assistance as well as disability. So we would ask if the court would consider allowing her some time to pay the fines in both these cases.
Ms. Holly, anything you want to say before the court imposes sentence?
No.
All right. In each case, it's $480 fines and costs, 93 days in jail suspended. So that's about $960. Is that right?
Yes.
Pardon?
Yes.
So how are you going to get that paid, man?
Hopefully on a payment plan.
Okay, so what do you want? Okay. So how soon can you get, let's start with one case, the 480. How long would that take you to pay?
I can do like 100 a month.
100 a month?
Mm-hmm. Yes.
That's 5 months. Okay, let's do this. I'll start it with case 0783, $100 per month. Beginning December 2025. On the other case, it will be $100 per month. Beginning in May 2026. All right. Thank you, ma'am.
Thank you.
Thank you, Your Honor. Thank you, Ms. Holly.
Court calls the
Thank
case of
you.
People versus Mikesha Melchor.
Good morning.
Assistant Public Defender Lauren Perry on behalf of Ms. Melchor. Ms. Melchor, state your name for the record, please.
Mikesha Melcher.
Melcher. Okay.
Your Honor, we did review the CSI and the recommendation. We do ask that you adopt it. I will say on behalf of my client, Ms. Melchor, just completed inpatient treatment. She transitioned to recovery housing, and now she is in that program and is transitioning to outpatient treatment this Friday. So she's doing some good things to improve her station.
All right. Ma'am, anything you want to tell the court before I impose sentence?
No, other than I appreciate the court working with me on my sobriety, and I'm just glad I'm getting myself together one day at a time.
Gotcha. Okay. Sentence of the court, $500 fines and costs, 365 days in jail, credit 3, the balance suspended. How can you get this paid, ma'am?
You can put me on a payment plan, please, Your Honor.
Okay. How much are you gonna pay per month?
$50 a month, if that's fine, please.
$50 per month, beginning December 2025. All right, thank you.
Yes, thank you. Have a great day. Thank you.
You too. Court calls the case, People versus Kenneth Miller.
Good morning, Mr. Miller. Mr. Miller, state your name for the record, please.
Kenneth Miller.
Your Honor, today is the date and time set for sentencing. I do ask that the court adopt the majority of the sentence recommendation, with the exception of the strand tether. We are asking for the court to consider ceasing that tether today. Mr. Miller, since this hearing or since this incident, did enroll in home division. He's been enrolled in home division for a couple months now. He did complete a parenting class through Orchard's Children's Services, which is notated in the recommendation. That has since been completed. I did reach out to them for completion proof. I haven't received that yet, though. Mr. Miller also did complete the victim's impact panel. There was a CPS case that was open as part of this incident, and that case has since been closed. So Mr. Miller has completed some good stuff since this incident happened last year. He has obviously taken responsibility for what happened and is working to improve things. So given all of that, we are asking for that, but ask that you adopt the rest of the.
Are you saying he wants to do the 4 days?
He does not want to do the 4
Okay,
days.
that's what I thought. Mr. Miller, anything you want to say before I impose sentence?
No, Your Honor.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of outpatient treatment and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of treatment. Therefore, the sentence of the court, you are placed on 24 months probation. You're to pay $1,055 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $720 probation oversight fees. When can you pay that?
I was hoping to set up a payment plan.
Do you have anything today?
I don't have anything today, but I will on Friday.
How much will you have on Friday?
I can pay like $50 on Friday.
This will never get paid in 24 months if it's $50.
It won't be. I can do like $200 a month.
Pay $50 this Friday, the 14th. And $200 per month beginning December.
Thank you.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete outpatient substance abuse treatment at home and revision, including all recommended aftercare with status reports to probation. You are to complete the parenting program through Orchard Children's Services with proof to probation. You're to provide proof of the victim's impact panel attendance to probation. I will continue the scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 180 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you.
Court does call the case of the People versus Diana Seaborn.
Good morning, Judge Simpson. Attorney Carl Jordan, P 57226, appearing on behalf of Ms. Deanna Seaborn, and Ms. Seaborn is present, Your Honor.
All right, go ahead.
First of all, Your Honor, I apologize for running late. I know that the time was changed, but I was in another court. No excuses. I apologize.
All right, very good.
Your Honor, with respect to Ms. Seaborn, she did plead no. I did go over the PSI with her. There are no additions, deletions, or corrections made. I would just like to address what I believe would be an appropriate sentence.
Yeah, go ahead.
They are asking, Your Honor, for 29 days, 365, and I believe that they're asking for that to be held in abeyance, but that you serve 29 days. I don't believe, Your Honor, that that would be appropriate. And I'm jumping straight to that aspect because, first of all, Ms. Seaborn is extremely remorseful for what happened. She did not give a statement because she was allowed to plead no contest due to civil liability. But make no mistake about it, she took her job seriously. She did not want to harm anyone, certainly not a special needs child. This is by no means an excuse, Your Honor. But when I asked her, why she may have done what she did, because she has no prior record, she said, being spat upon at that point, she just kind of lost it. But again, I am by no means saying that that is an excuse, Your Honor, especially when you consider it as a child, and especially when you consider it as a special needs child. But I do want the court to know that had that not occurred, she would not be before any criminal judge. And I do not believe that she will be in front of any criminal judge in the future. She will complete probation successfully and go on and live her life. There have been some consequences. She did lose her job that she had as a result of these charges. So now she is doing DoorDash in addition to taking care of her sister. But again, she's sorry, she's remorseful, and she wants the court to know she has learned her lesson. Thank you, Your Honor.
Anything you want to say before I impose sentence?
No.
Well, I'm going to say this, counsel, and I appreciate the elocution. However, when I look at the circumstances of this case, this is a special needs child. Certainly some things are going to occur. Certainly it can maybe raise one's ire, but to do these things is, in my estimation, inexcusable. I mean, these parents, through each stage of a process on a day-to-day basis, entrust their child to these folks. And quite frankly, when you violate that trust, it's inexcusable in a lot of ways, in my mind. I mean, in particular, that this is a child that really cannot defend themselves if they even comprehend exactly what's happening to them. I mean, which just has to be sort of the worst thing. Was there a victim's impact statement? I was expecting that there might be.
I did not receive one, and I do not see the victims present.
All right. It is a sentence of the court. Place you on probation for a period of 60 months. You're to pay $655 fines and court costs, $1,800 probation oversight fees. When can that be paid?
You said 1,800, Your Honor?
Yes, that's what I have. Yeah, it's 60 months.
Your Honor, she realistically says that she can pay $150 a month.
Okay. $150 a month. That will begin in January 2026.
Thank you, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the anger habits program. You're to complete 50 hours of community service. There's to be no contact with Elizabeth, Peter, or Eli Lorensky, if I'm pronouncing that last name correctly, that is directly or indirectly. You are not to be working with and or around any minor children. There's to be no assaultive, threatening, or intimidating behavior by you. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. And let me just say this. You know, like I said, these parents entrust you. And, you know, at no point, other than for the purposes of safety or other legitimate reasons, do you have the right to place your hands on that child? That's the only basis of you're trained, should have been trained, and I think you were, as to how to deal with these circumstances and these situations. You're having a bad day, losing control, and doing this kind of thing is never an option. And I understand counsel isn't saying it is an excuse, but it's not an option for you when you get into that role and in that circumstance. And so what I'm going to do is I'm going to order 365 days in jail. Give you credit for the 1 day that you serve. You will be remanded to serve an additional 29 days, and then the balance will be suspended. Defendant is remanded.
Your Honor, I spoke to my client about this, and she said, could she have time to get her affairs in order? And I said, well, really, what affairs do you need to get in order? I mean, you know, the president of the United States could get his affairs in order probably quickly. And she said, I do have a daughter who's 14, and I wasn't expecting to have to serve any time because it wasn't part of the negotiations. May she have at least a few days so that she can arrange for a 14-year-old to go somewhere? She does have a sister, but her sister is a person that she takes care of. Her sister was shot. She's in the courtroom. So she truly does need to make provisions with respect to her daughter. And she understands if she...
At the moment this was happening with the child, was that child permitted to make any arrangements for their care? Probably not.
Of course not.
I will not pay her the same courtesy. Defendant's remanded. She'll go today.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Lucille Slater.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater, who is approaching. Please state your name for the record, ma'am. Lucille Slater.
Thank you.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Ms. Slater. We only have one brief correction, and that is on page 2 under the summary. It states that she pled no contest to this charge on the date of her pretrial hearing on the 17th. That is correct that it occurred on the 17th, but that was the date of her final settlement conference. That is the only correction we have, Your Honor. And as to the recommendation, I do believe it to be fair recommendation, and I would ultimately ask the court to adopt it. Ms. Slater presents to the court, she's 76 years old with no prior convictions of any kind. This is quite literally her first rodeo in this situation. She has, throughout my representation of her, taken this matter very seriously and has, to me, shown a lot of remorse for her actions on that day. She, prior to this incident, she had worked at this position for almost 7 years, and to my knowledge, had no other prior incidents of this kind. This is her first interaction with the criminal justice system. She has expressed much remorse to me. To my understanding, she has complied with her bond to the T and has appeared in person for all her court dates. I would ask that the court adopt this recommendation.
Ma'am, is there anything you want to say before the court imposes a sentence?
No, Your Honor, I'm sorry to interrupt.
Yes, I will get to that in just a moment. I was aware.
No, Your Honor.
All right. You guys are going to need to have a seat here. All right. Please, somebody. I'm sorry. I understand there's a victim's impact statement.
Yes, Your Honor. The minor child's mother and father is Julie and Ryan Franks. They are present.
Julie and Ryan.
Julie and Ryan.
Got it. Hello.
Hi, Your Honor.
Could you state your names for the record?
Yeah, Julie Franks.
Ryan Franks. All right, thank you. And I'll need you to take your hands out of your pockets if you would. Thank you. All right, I think we're all set now. Go ahead.
Thank you, Your Honor. Thank you for giving us the opportunity to speak today. We are here as the parents of a 7-year-old little girl who was physically grabbed and yelled at by Ms. Slater at school. a place where she should have felt completely safe. That day changed our daughter. Since then, Natalie has struggled with anxiety and fear. She often asks questions no child should have to ask. Things like, why did that happen? And will that happen to me again? It has been incredibly painful as her parents to watch her confidence fade and to see her question the trust she used to have in the adults around her. We spent months trying to rebuild her sense of safety through reassurance, through love, but this incident left a mark. It's something she carries and will carry with her forever, and something we, as her parents, will never forget. What's been equally hard is seeing how little remorse Ms. Slater has shown. When police reached out to get her statement, she hung up on them and blocked their number. That forced us to move forward and press charges. When officers went to her home, she refused to answer the door, even though they could clearly hear people inside. Those actions speak volumes. They show a complete lack of accountability, of remorse, and of understanding of the harm she caused. We truly believe that if given the opportunity, she could have hurt another child. We understand that everyone makes mistakes, but when an adult's action causes emotional and physical harm to a child, that can't be taken lightly. Our greatest hope is that the court ensures that this individual is not in a position to work or be responsible for children. No family should have to go through what ours has. We're speaking today, not just for our daughter, but for every child who deserves to feel safe and protected at school. That's all any parents want, to know that their child is safe when they walk through those doors. Thank you, Your Honor, for listening to our story and for considering the impact this has had on our daughter and our family.
Thank you for coming down. All right. All right. Is there anything she wants to say now?
Just very briefly, Your Honor, I do want to mention Ms. Slater has taken accountability and has expressed remorse in this matter. Of course, to me, and of course, by entering a plea in this case. She takes accountability for what actions did occur, and she is remorseful. I can say that through my many discussions with Ms. Slater, and she does take accountability for what did occur. And I do believe she is remorseful, and her choice not to give a voluntary statement to the police, I believe, was based on the advice she had received through counsel and other means. That being said, she is remorseful for her actions and has taken accountability.
Ma'am, anything you want to say?
No, Your Honor.
Okay. So I get the notion that prior to anything happening, and I can understand why it might confuse the Franks, or they're not appreciating that she may have been told by, she was a union employee or through lawyers not to say anything, not to have contact. So I get that, and that might be, one might expect as a parent that somebody might act a little bit differently, but I get why somebody would act. I am, however, a bit concerned that as we get here today, as we are here today, that there's this little girl and something happened to her. And standing there in her stead are her parents who have taken their time to come down to let the court know basically the effect that this has had on their child, which I guess spoken like true parents, but also moms will do this. They don't express necessarily the impact that it's had on them, but they talk about what's happened to their child. And I did something different because I was told prior to this hearing and in reading the report that there wasn't a sense of remorse for what had happened. Even if done accidental, even if done out of a misapplied sense of how to have this child saved. They were people saying, well, she's not really showing remorse. She didn't really care what happened to this child. And where I did something different, because my staff here knows how I typically will handle these situations when I have impact statements. You would have sat down. They would have spoken to me, and then you would come back up. But I would not have addressed you prior to Frank speaking. Do it that way pretty much every time. I did it differently for a reason today. Because I was at least going to give you maybe 2 opportunities to look that little girl's parents in the eyes. And whether or not you meant to do what you did, just to tell them you're sorry. Because that's their baby girl. And I gave you those 2 opportunities the first time. Nothing. You sat down, you heard mom speak, came back up, asked you again, and nothing. I don't know how you do that. It puts into perspective for this court what happened that day. Because I sat there and I thought to myself, well, here's somebody who works for the school. Things can get out of control. They can do this, but you know, it's just like I told the person before you. I'm not sure that you've got a right, except for the purpose for safety reasons or other necessary reasons, to put your hands on somebody else's child. You can't do it. And then if you lose your mind for a minute, for whatever the reason, and you do, then quite frankly, you take responsibility for it. You say, I shouldn't have done it. And if you can't apologize to the little person, you apologize to her parents. So at least her parents can go and say, hey, look, she apologized. This is her version of it. She didn't mean it. And they can sort of move forward with that lesson that they're entrusted to teach their child. But you can't even do that.
If I may, Your Honor, my client and I have had to discuss the no contact order multiple times, partially for that reason. I've had to remind her that she is under a court order not to reach out to the Franks and apologize, not just the minor child, but as the adults. And pursuant to that court order, she has not had any contact with them whatsoever, good, bad, or indifferent. And she is sorry to the Franks.
But today, Miss Pate, that's what I'm talking about. I get everything maybe before they got here today. But for God's sakes, there are parents here that are talking about what trauma has happened to their child at your client's hands. And she didn't even have to look at her. She could have told me, as people do, that she's sorry, but nothing.
But I am sorry, sir.
And Your Honor, I would like to reiterate, and not to speak out of turn, Ms. Slater is very nervous about being in front of Your Honor and in this court today. And I do reiterate that she is 76 years old and this is her first time coming to court, to my knowledge, for anything, but I know for a fact for something like this. She has expressed her remorse to me multiple times. I've had to remind her of the no contact order for that purpose. And I do understand what the court is saying and her not saying anything today. However, I can represent to the court that she has expressed remorse to me about this incident. And she has wished she could apologize privately, but for the no contact.
That's all fine and dandy. But how do they know that to say that to their little girl? They don't.
It's unfortunately one of those situations with our, our system, which of course there's very much a need for no
This
contact.
is not, no, today I get beforehand. But today I gave her 2 opportunities. She doesn't have to even look at them to just say she's sorry, and she didn't.
She did, Your Honor. Right. I just want to make sure the court heard. I'm sorry. She said it a little quiet.
Oh, I heard it. Too late. Is that said, because at this point, I don't know if that's said because she's really sorry and remorseful about what's happened to this little girl, or if she's only saying that because I pointed out that she didn't.
Your Honor, what I can say is before today, she's expressed remorse to me. And as Your Honor knows, I do represent a lot of clients, and quite candidly, there are a lot of clients who don't. And unfortunately, I don't have the opportunity to say that about them. But in Ms. Slater's case, I can say that. We've had several meetings outside of court as well, in person in my office, both to discuss this case. And quite candidly, since the beginning, Ms. Slater has both been apologetic, but also wanted to take accountability. I believe one of her words to me, our in-person meeting when we were reviewing the footage of the incident in my office was, I believe I deserve some sort of punishment, and I want to be sorry and move this behind me, and I know I can't reach out to the parents. And of course, at that time, I reiterated, no, absolutely not. Do not reach out to the parents. You're under the no contact order.
I have to give the Franks credit, because I think that had been my daughter. I would have lost my darn mind. I'm not even going to pretend I would do something different than that. But that's me. It's a sentence of the court. I'm going to place you on 18 months prosecuted deferred sentence. And I'm going to let you know that in my mind that I wasn't sure whether or not I was even going to allow the deferred. I looked at your lack of record and decided that I would indeed give that to you. But initially, my first thought was I wasn't going to give you the benefit of even being part of that program. But I will place you on that program for a period of 18 months. $455 fines and costs, $540 probation oversight fees. When can that be paid?
Your Honor, my client says she can pay $200 today and is asking for a payment plan as to the rest.
How much can she pay per month? Well, no, I'm going to make it $200. She's to pay by December 22nd, 2025, and then a payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. I am ordering no contact with Julie, Ryan, Natalie Franks directly or indirect. I'm ordering that there be no working with and or around any minor children. There is to be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will set a review hearing on this case that is to be held May 12th, 2027 at 9 a.m. With reference to jail time, ma'am, I have taken into account who you are and what I could see on this paper. I've taken into account the things that I've said on the record. And I've taken into account, as I did with the deferred sentence, the fact that a lack of record for your entire life, at least as we see it here. But you can't grab someone's child. You just can't.
Understood.
So it's 90 days in Washington County Jail. Defendant is to serve 15 days. The balance of that time will be suspended. Defendant is remanded.
Your Honor, I know Your Honor has issued a ruling, but can I make a request that her to be able to turn herself in a few days? Her husband does have some severe health issues, and I'm just asking, given.
I need medical regarding that, and I will consider it, but right now she's going. Okay. Court does call the case of the People versus Myra South.
Hi. I'm sorry.
Miss South.
Okay. I'm sorry. I just saw. Defendant Lawrence bringing it back with Miss South. Miss South, state your name for record, please.
Myra South.
Oh, good. Now, we did review this case in the report. We don't have any material deletions. We do ask that you adopt probation's recommendation regarding the fines and costs. Ms. South has been through a tough period of life as reflected in the investigators' summary. She was homeless when this case arose. She recently got back into work. She completed school. However, she just lost her job because her car broke down, I believe. Whatever happened, she didn't have transportation to work. She lost her job. So now she's out of work again. Ms. South has been really putting a lot of effort to get things on track. So I am asking that the court take that into consideration and give her some time to pay that. She told me today she's going to work something out, but we'll definitely need some time.
Charles, anything you want to say?
Hi everyone. So this situation is just, I hate that I have to go through it or am going through it, but just please allow me some time to pay my balance and thank you. I don't know if I should say thank you, but thank you for helping. I don't know. And hopefully you never ever see me again, because this is not how my life is. This is not, yeah, I don't. But thank you, Your Honor.
All right. It's a sentence of the court, 6 months probationary term. I'll order $400 fines and costs, $180 probation oversight fees. Ma'am, you went back to school?
Yes, sir, I did. Yes, Your Honor.
And what did you get your degree in? Or what did you decide to be when you grow up?
It just took me about 30 years to figure that out. I'm a massage therapist. I'm a massage therapist.
Okay, so you went back to school. All right, fantastic. Yes, all right, so what I'm going to do is I'll order the $400 fines, $180 probation oversight fees. That is to be paid as arranged by probation. So when you get yourself employed, just keep in touch with us, Valera, and try to make sure that you're on a payment plan that you could do, okay?
Yes, sir. Thank you so much, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation.
Okay.
You are to complete a gun safety class as directed by probation. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. I will order a forfeiture of the weapon as indicated in the file to 9mm. I will order 90 days in jail, credit 2 days, the balance is suspended. All right?
Thank you.
Thank you, ma'am. Thank you. You take care.
You as well. Have a great day, guys.
All righty. Court that's called case of the People's State of Michigan versus Theodore Mills.
Chris Blair on behalf of the patient. Your Honor, Mr. Mills was put on today's docket. The defendant is deceased. Documentation was obtained through the CLEAR program showing that he is deceased. Given that probation is asking that the terms be waived, including the financial obligations, and that he be discharged from probation without improvement in the case before.
Assistant Public Defender Lauren Hardy on behalf of Mr. Health.
So ordered. Court does call the case People versus Durante Bonner.
Assistant Public Defender Natalie Pate on behalf of Mr. Bonner, who may be present via Zoom. Mr.
Bonner? Not checked in.
Your Honor, the number I have unfortunately is disconnected, and I do understand that this is a review for payment. It does, I believe, it still has a balance. I have no explanation for his failure to appear, and for the record, would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set. How much is it? Bond will be set in the amount of $25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls the case of the People versus Anthony King.
Assistant Public Defender Natalie Pate for Mr. King, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name for the court? Your Honor, we did have contact with him this week, and we're going to be requesting an adjournment. I have no explanation for his failure to appear today, excuse me. And for the record, request an adjournment.
It's about 22, 23. Bench warrant will issue bond $25,000. Give a 10% privilege. Warrant will issue immediately. Court calls case of the People versus Middleton. You weren't gonna catch me this time. State your name, please.
Saquangela Middleton.
That's exactly what I was going to say. All right. Where is this a show cause? Mine's a cause. Okay. I don't have probation review.
I'm sorry, who was that?
No, money.
Oh.
No. Hold on a second. I think it's because of her fines and costs. She hasn't paid.
Yes, it's just you. I can check your honor. So she has no counsel.
All right. You haven't paid. You're here on a show cause failure to pay fines and costs, Ms. Middleton. Did you want to be represented by an attorney?
I mean, if I could just talk to you, I mean, I don't know.
You
just
can talk to me.
Okay, so look, I'm just tell you, be honest, I'm broke. I have other obligations, and I thought I can handle it, and it's just very hard. I mean, I could try my best. I'm gonna do my best. Every month I can do like 25. If you can extend the date for me to pay it.
When can you start that?
December. December? Yes.
You're gonna $25 a month?
Yes.
You sure?
Yes.
Where'd you get that first name?
Oh, I was born and raised in Georgia, so it's like country.
Wow. You just lambasted the whole state, didn't you?
Yes. Oh my God.
It's
Down
all
there.
right. All right. What I'll indicate, defendant to pay $25 per month. Do we have? All right. And that's to begin in December.
Okay.
And then I'll adjourn this hearing out to, is it going to be March 4th or 5th? Is it a leap year?
March 11th.
Oh, of course. So I'll adjourn this to March 11th, 2026, 9
Can
a.m.
it please be Zoom?
You have to fill the paperwork out.
Oh, I mean, okay.
Wow, really?
I'm so sorry. I'm
Really?
sorry. I'm
I
sorry.
just said you need to fill the paper. That's
Okay, I'm sorry. You're right.
why'd you do that?
I know I was thinking it and then it's just
Yeah, I know. It just came out.
it came. I apologize.
That's a Georgia thing.
Yeah. Yes, for sure.
Don't even try to blame. Don't be blaming it on that state. That's all you. Just get those payments in.
All right. Thank you.
Thank you.
Bye.
Court calls the case People versus Marie Shemwell.
Public Defender Natalie Pate with and on behalf of Mr. Shumwell, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Maurice Shemwell.
Thank you, sir.
Thank you, Your Honor. It is my understanding that Mr. Shumwell's balance is currently $1,780. He did make $25 payments on September 30th, October 24th, as well as November 4th. To that end, I believe he would be requesting a payment plan in order to continue getting his balance paid off.
And how much is he going to pay per month?
Mr. Shumwell, were you requesting a $50 monthly payment plan?
$25 would be better for me right now, if possible.
You're never going to get this paid off.
I've been having some back problems. I'm going through a little surgeries right now, waiting for a little disability. So my financial problems is pretty bad right now, Your Honor.
Defendant to pay $25 per month beginning in December. I'll adjourn this matter out March 11th, 2025, 9 a.m. Thank you.
Thank you,
Thank you, Your Honor.
Mr. Shumwell.
Thank you.
Court does call the case of People versus Andre Smith.
Teresa Clare on behalf of probation, Your Honor, Mr. Smith was scheduled before the court today for a review hearing on a prosecutor deferred. He did complete all terms ordered by the court, and I did clearance. Probation recommended that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation.
Got objection, so ordered. Court calls the case of the People versus Sean Costello.
Public Defender with and on behalf of Mr. Costello, who is present via Zoom. Sir, could you please unmute and state your name for the record?
Mr. Costello, can you hear us? There's something wrong with this.
Yes, I can
Wi-Fi.
hear you.
Oh, can you say your name, Mr. Costello?
Sean Costello?
Thank you, Your Honor. I did just get another update from Mr. Costello this morning. He left me a voicemail saying that he's currently back at Arborlight in Monroe. To that end, his status and inpatient treatment. I'd be asking for an adjournment of the show cause.
I'll adjourn the matter
My mistake. File B, failure to disclose concealed pistol. That's a mandatory fine of it calls for fines of 610. It's a civil infraction. So I apologize. I didn't call that. And then file C was a civil infraction, but that was dismissed.
Yes,
So
Your Honor.
any material additions, corrections, or deletions?
No,
Anything you would like to say on his behalf?
just very briefly, Your Honor. I'd ask the court to adopt the recommendations contained therein. Now, he has moved to Leslie, which is between Jackson and Lansing, and it's about a 90 minute drive away from this area. So I was going to ask, is there any, I don't have any problem with any of the recommendations, including the testing and everything. And everything else is reasonable under the circumstances, the level 2 alcohol program, getting his GED or diploma, maintaining employment. In fact, he just got he's getting a job. He just got a job offer and he's going to start working shortly. I think everything is reasonable under the circumstances, Your Honor. I just ask Your Honor if you would consider allowing him to potentially report via Zoom.
Yeah, well, they'll let him do that. They'll figure out a way for him to test up there.
Okay.
Okay. Anything else?
That's what I was concerned about, Your Honor. And then after sentencing, I might have something. Let me just say this, Your Honor, if you're inclined to adopt the recommendation, I don't have any further elocution.
Yeah, I'm not inclined to. He's going to do outpatient treatment. He's still a young man. He had a prior. He kind of got lucky here. You did a real good job, but I'm going to order outpatient. And everything else, pretty much the same, but I am going to order monthly testing for 6 months, then on demand. So if you want to argue something to the contrary, feel free. If not, I'll just...
No, Your Honor, the only other thing I want to address very briefly is he was a valid CPL holder. I think he still is. We'd asked for return of the firearm. He wasn't,
You just get the prosecutor to stipulate to that. You get the prosecutor to stipulate to that. If he won't, you're going to have to file a motion.
Okay.
Okay?
I got you,
I'm sure he won't have a problem. You
Yeah,
can
I don't
call
think he will.
him, but I'll need an order from you, okay?
Okay, I'll send him an order.
Sir, anything?
No, Your Honor.
So you're getting lucky here. If you didn't get this reduced, you get another one. You're committing a felony. Do you understand that?
Yes, Your Honor.
You got to be careful, son. 12 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing PBTs and ETGs monthly for 6 months. If you're clean, I'll then make it on demand. Kratom poppy seeds and CBD oils are prohibited. If you consume food or other items containing those substances, it will be deemed a violation. Again, no alcohol, no marijuana, no illegal drugs. Obtain and maintain employment, provide proof. Obtain a high school diploma or GED. Attend AA, NA twice a week until you're in outpatient treatment. Once you get in outpatient, you no longer have to attend AA or NA. Attend the Victims Impact Panel. Serve 4 days jail, credit 1. I'll let you serve those by way of community service. 3 days community service or 24 hours by January 5 of 26. 300 fines, 350 costs, 75 if and Droits fee, $50 justice assessment. So your fines and costs here are $775. Probation fees are $240 for 1,015. Screening $60, $1,075. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
I'm sorry, I didn't hear you, sir.
Yes, Your Honor.
All right. You seem like a nice kid. Stay out of here, will you, please? Really? And again, I'll make a note here. Can report by Zoom.
Thank you, Your Honor.
And you may be eligible for early discharge if you complete everything within 6 months, or after 6 months, you'll be eligible.
Okay.
Okay, what else? Does he have all this to pay, counsel?
No, he doesn't. He's been, he was laid off, unfortunately, and he's just getting into a new job. So I'm going to ask for a payment plan, Your Honor.
Give me the, tell me at what rate.
Can he,
How about 75 a week starting December 19th?
That's great.
And if he doesn't have the money, you can tell him, you know this, you can call the court, we'll go on Zoom, I'll give him an extension. Now, the 26th, we are closed. Also, I forgot to say, he's going to pay fines and costs of $610 on the other file, and that's on the fair and disclose, and I'm going to give him, I'm just going to say pay this one by June 1 of 26. Okay? So you pay that by June 1 of 26. And you take care of these others. Again, if you don't have the money at any point, it's not a problem. Call the court. We'll go on Zoom. I'll give you an extension as long as you do it before the due date. Okay?
Thank you, Your Honor.
Thank you very much, Mr. Blanche. Sir, good luck to you.
Is the probation officer going to reach out to him, or do you want him to come in and see probation?
Why don't you call over there right now? I don't know if we're shorthanded. Again, it's 734-671-0201. Extension 245.
Okay, do you know who is a probation officer is going to be on this one?
I have no idea. It looks like you can tell them it looks like the report. Let me see. Was prepared by Jessica. So you can tell them Jessica prepared the report.
Okay, I'll do that, Your Honor. Thank you so much.
You have a good day.
Have a good day.
You too. Amy Renee Wilhelm, 19B 134738A. Your name, ma'am?
Yes, Amy Renee Wilhelm.
You have a probation violation. They think you failed to attend your scheduled probation visits on March 17 and March 28 of 22. You failed to attend the victim's impact panel. You failed to submit the chemical testing as ordered. You failed to provide verification of attending NA 6 times a week until an IOP. And you failed to provide verification of attending and completing intensive outpatient treatment. So those are the charges. Will you want me to just get you a lawyer now, ma'am?
I'm not sure what to do.
Well, wait a minute. Slow down.
This is the thing. I lost my fiance 3 days
Wait a
after.
minute. Wait. Let's get you a lawyer, okay? We're going to set you up with a lawyer on Zoom. I'm sorry about your fiance. You can't do this though. You've not been here in 3 years.
I was staying out of trouble. I was taking care of a handicapped friend of mine.
Okay, you talk to your lawyer and then you'll come back in front of me, okay? So we're going to give her a lawyer on this one, John. Okay? Grant? Let me see. Who's your lawyer? Okay, Grant Avery Galaska. 25WA38970.
Michael Apartment P7324, but have to attend, Your Honor.
Your name? Come up to the podium.
Grant Avery Galaska.
So, counsel, for purposes of arraignment.
Stand mute, wait the phone reading, Your Honor.
And now, as I understand it, you pre-tried this case with the prosecutor. There's going to be a plea to attempt stalking, and this is under local ordinance, and they're going to dismiss the original charge of stalking. True?
Yes, sir.
If we do that, the possible penalties, if you do that, sir, the possible penalties are up to 250 fines, 45 days jail costs, or all of those penalties. Do you understand that?
Yes, sir.
Did you sign, read, and understand an advice of rights form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
You understand all your rights?
I do, Your Honor.
You have any questions before I proceed?
No, Your Honor.
to the charge of attempted stalking. How do you wish to plead?
Guilty.
Were you in the city of Woodhaven, county of Wayne, on October, let me look at the report first, on October 12th of 45, did you contact, on or about October 12th, did you contact the Brianna Sanchez?
Yes, Your Honor.
How many times did you contact her?
Multiple times, Your Honor.
How many's multiple? That could be 3, it could be
Over
800.
this time, Your Honor.
And what did you contact her, by phone or in person?
Via phone.
And was she a person that you had an interest?
I had a relationship for 9 years with this person.
Okay, and what did you do when you contacted her on those 9 occasions?
I told her basically like I would like to have a conversation because we were going to, and she wanted to end the relationship over text. And
over by text?
Yes, Your Honor.
Okay, and then
I'm the type of person where I like to do encounters face to face.
all right, so you told her you wanted to talk to her.
Yes, Your Honor.
And what did you tell her? Did you swear at her or use any threatening language? Or, let me finish. At some point, Officer Prokes told you to stop contacting her, true?
Yes, Your Honor.
And after that time, you still contacted her, true?
Yes, Your Honor.
And on the first few occasions before he told you not to contact her, what was the substance of your conversations or voicemails with her?
Basically saying that I would like to meet up and have a face-to-face conversation. And
use vulgar language?
They had used.
Do you remember? This wasn't that long ago, right?
No, Your Honor.
Well, tell me, come on, not may have. You know what you did or didn't do.
I do believe I did use profanity.
Well, do you remember using profanity?
Yes.
You don't have any learning disabilities, right? All right, come on, just tell me. I'm not a dentist. I'm a judge. Tell me what happened.
Yeah, so over there in the voicemails, I do remember calling her a bitch and being unreasonable and that this was out of line.
What else did you say besides using the B word?
I know I dropped that bomb a few times, but those.
In the first conversations before Prokes told you not to contact her, true?
Yes.
And then after Prokes told you not to contact her, Officer Prokes, what did you do?
I did send an email.
What did the email say?
It was basically saying, I wish we could have sat down somewhere.
Did you use some vulgarities there?
No.
You just said, I wish we could have sat down?
I wish we could have sat down, had a normal conversation and didn't have to get to this extent, Your Honor.
All right, but in the first several conversations, true or false? I don't want to put words in your mouth.
Before I
listen, you used vulgar language with her, right?
Yes, Your Honor.
You threw out some F-bombs and called her a bitch, true?
Yes, Your Honor.
On how many of those phone calls did you use that language?
Probably 3 of those conversations.
Were they voicemails that you left?
Yes, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Have you had any contact with her since?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Ever been in trouble before?
One time.
For what?
It was petty theft when I was 17 or 18 years old, Your Honor.
Just give me 1 second. And she lives on Van Horn, right?
Yes, Your Honor.
All right. Where do you live?
I live on Cranbrook Street in Riverview, Michigan.
Do I have to order you to put a tether on?
No, Your Honor.
If I order you to put a tether on, you know what's going to happen?
What is that, Your Honor?
They're going to send you downtown and you're going to be stuck there because they're not going to give, even if I give you a personal bond, you're going to be stuck there for 6 days or 5 days until they can fit you with a tether. Do I need to do that?
No, Your Honor.
You're not going to talk to her again, right?
No, Your Honor. I've learned my lesson that if something doesn't serve you, you cut it at that.
How old are you?
I'm 29 years old, Your Honor.
And you work?
Yes, Your Honor.
And I'm sorry, where?
K-9 Plane and one that I am a machine operator.
Good. All right, here's what I'm doing. Mr. I'm going to order a pre-sentence report. I'm accepting the plea to attempted stalking. I'm dismissing the stalking. I'm going to refer you for a pre-sentence report. I'm going to set some bond conditions. And here are your bond conditions. I'm giving you a $2,500 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You're not to have any contact at all with Brianna Sanchez or prosecution witnesses, except through your lawyer. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you or on your behalf. No contact with Ms. Sanchez, no contact with prosecution witnesses. You're not to enter or go near 18638 Van Horn, apartment 12 in Woodhaven. You're to return to the Woodhaven Police Department, be fingerprinted and photographed by 1 p.m. today. You're going to go down the hall. We're going to give you a notice. Then you're going to go over across the hall to probation, where you will be interviewed. Then they'll prepare a report and recommendation. You'll come back on your sentence date. When you go down the hall, we are going to give you an order for prints and photographs. It's the condition of your bond. We'll give you that. We'll give you the bond sheet. We'll give you a notice. You go over to Woodhaven, you get printed and photographed. And your sentence date will be on.
We can do 11/24. Is that too soon?
No.
Okay.
November 24 at 8:30. Is Mr. Carmen here that day?
He is. I think he's an arraignment attorney that day.
Perfect. November 24th at 8:30 in the morning. I'll be ready to go at 8:30.
I'm not here that day, Ron.
You're not? You're not the arraignment attorney.
Oh, I thought you said Mr. Crawford. I'm sorry. No, Mr. Carmen is not here.
Well, what do you want me to do? I could set it when Mr. Carmen is here with a week later if you want. There's no real rush. He knows better than to go near her.
Mr. Carmen is here next, it looks like, with Judge Hessen on 12/3 or.
What else do you have, Tony?
I'm
Yeah,
overflow December 10th.
You want to do it on the overflow date? We'll just do it December 10th, Amy, at 8:30, okay?
All right.
Do you understand everything, sir?
Yes.
Do you have any questions?
No, Your Honor.
I do wish you well. Good luck. Thank you.
Thank you, Your Honor. Thank you, Your
All
Honor.
right, Charles Lester Laney. This is file number 25.